Good evening, ladies and gentlemen, members of council. Are there any disclosures of pecuniary interest this evening? Councillor Dunn?
Through you, Your Worship. I had a pecuniary interest on report, I believe it was LLS-57-18 in the confidential closed session regarding property ownership.
Okay, anything further? Nothing then. We'll move on to the approval of the council minutes. Looking for a mover and seconder in regard to the special closed meeting held August 13th. Councillor Wilkinson, Councillor Hammond. Discussion on the motion. All in favor? Carried. And the same thing for the council meeting held August 13th. Moved by Councillor Jacobs, support by the Deputy Mayor. Discussion on that motion. All in favor? And carried. Is there any business arising out of any of those minutes? Nope. Then we'll move on to reports of staff and delegations. So this evening we're starting off with one regarding public information open house, revisions and additions to the Register of Heritage Properties. And Miss Ashton, yes.
Hello.
Yep.
That's loud. Good evening, Your Worship and members of council. Okay. This is regarding, regarding Public Information Open House 2018 and revisions in addition to the Register of Heritage Properties. Leamington's Register of Heritage Properties was adopted on September 26, 2016 and contains 4 designated properties under Part 4 of the Ontario Heritage Act and 270 properties that are listed as having heritage potential. Section 29 of the Ontario Heritage Act enables municipalities to pass bylaws for the protection of individual properties that have cultural heritage value or interest to the municipality. A designated property cannot be demolished or altered in such a way as to affect the heritage attributes of the property without the approval from council. The Ontario Heritage Act also permits a property that has not been designated but that council believes to be of cultural heritage value or interest to be placed on the register. This is commonly referred to as listing. On August 9th, 2018, owners of both listed and designated properties of cultural heritage value, as well as owners of the 6 potential additions and the general public, were invited to a public information open house, which was hosted by the Leamington Municipal Heritage Advisory Committee. The purpose of the open house was to provide information regarding the Ontario Heritage Act, the importance of protecting heritage resources, such as properties and dwellings, and the impact of being on the register. A total of 24 people signed into attendance at the public open house, including many owners who were eager to receive the information as well as share information about their properties. Based on the sign-in sheet and discussions with those in attendance, 1 property owner of a home listed as an addition attended the public open house. At the event, the Heritage Committee offered property owners and members of the general public a chance to complete a short heritage survey. The purpose of the survey was to get feedback from heritage property owners and the community about their views on heritage in Leamington and what initiatives they feel would be beneficial to preserving heritage in Leamington. For example, heritage walking tours, financial incentives, plaque programs, property research, and workshops or seminars. The majority of property owners were interested in how they could benefit from being a listed or designated property financially in order to provide proper maintenance to their properties. The Heritage Survey was administered at the public open house and was then made available on the Leamington webpage until August 19, 2018. The link to the survey was also shared with Heritage Committee members, Communities in Bloom members, and the Historical Society. In total, there were 25 responses. Comments from the Heritage Survey can be seen in Figure 2. The most current survey results indicated that 16 out of 25 people said that they were the owner of a listed heritage property, and 6 were residents interested in Leamington's heritage. 18 out of 25 people said that conserving heritage in Leamington is very important, while 7 people said it was somewhat important. 18 people said that if Leamington's neighborhoods were featured in a heritage walking tour, they would be interested in walking a tour, with 12 people saying they would be interested in having their property featured in a heritage walking brochure. 13 out of 23 people said they would be very interested in having the history of their property researched, while only one said that they were not at all interested. 14 out of 23 people said they'd be willing to submit a nominal fee to have the Heritage Committee research the history of their property. 19 out of 23 people said that if their property was researched by the Heritage Committee, they would be willing to display a plaque on the facade of their building to recognize and share important information about their property. All those who took the survey, except for one person, said they would like to see some form of financial incentives offered to heritage property owners. The register is intended to be a dynamic document that is revised and updated as needed and as local resources and information becomes available. Properties can be added or removed from the register by council in consultation with the Heritage Committee. Administration has completed revisions to the 2016 adopted Register of Heritage Properties, which include minor grammar corrections, removal of the individual property tax assessment roll number from each page, changing the reference from Talbot Road West to Talbot Street West for specific properties, and correcting the reference to a demolished structure on a greenhouse property. In addition to the revisions, there were 6 proposed additions to the register being recommended by the Heritage Committee, which can be seen in Figure 1. 130 Erie Street North, 327 Seacliff Drive West, 330 Seacliff Drive West, 426 Highway 77, 321 Mercier Road 5, and 519 Mercier Road 7. The 6 properties were reviewed and approved by the Heritage Committee on June 27, 2018. All were approved to be sufficient for a listed status based on roadside inventory, the recorded date of construction, any known historical references or photos, and the determined architectural style and features. There is no financial impacts to the municipality as a result of the revisions and additions to the Municipal Register of Heritage Properties. With that being said, it is recommended that Council accept the minor revisions to Leamington's Register of Heritage Properties and that Council adopt the following additions of properties with heritage potential to Leamington's Register of Heritage Properties with a listed status. Thank you.
Thank you very much. Questions from council? Deputy Mayor?
Thank you, Mr. Mayor. Olivia, a couple questions. So a designated property cannot be demolished or altered in such a way as to affect the heritage attributes of the property. How strict are we with that? I know in other municipalities, they can be as strict as deciding what type of window and what type of paint. Are we being that specific?
So the heritage attributes are determined what is written in the bylaw. Our bylaws are currently most of them have been written in the 80s. So right now they're not super specific. There might need to be some revisions done to those probably. But it's based on what is in the bylaw, what is written. So it would be anything that is specified in there. So if, for example, the windows aren't specified, then it wouldn't affect those as being a heritage attribute.
Wow, I have a problem not knowing what those specifics are to go along with this because I feel like I'm putting an onus on the property owner. Well, then further to that, you said somewhere here the council is the one that removes the designation. Can the owners ask for removal and it's automatically granted, or does that have to go through a process, and is it a fairly onerous process?
From my understanding, there is a repeal process that can be done. I'm not sure the specifics are what they are, but I'm trying to think if Ruth wants to help me on that one.
Ms. Horton?
Designated properties are designated by bylaw, and that bylaw has been passed by council. And as Olivia indicated, there has not been a lot of designations in Leamington. The ones that were done a number of years ago. And as she indicated, the specifics attributes would be listed in those bylaws. if someone wishes to, for their property to be no longer designated, then it would be an application process. The matter would have to come before council, and council could either repeal or amend the bylaw accordingly. I just want to be clear that Olivia's report speaks to properties to be registered and not designated. So they're just listed on the register, which does not bring with it any specific attributes that are designated by bylaw. That would be an additional process that would have to come before council for that to occur.
If I may, then, thank you. I appreciate knowing that, because I feel that the more names we add to this, we need to then fine-tune that bylaw, should we not, if we're going to keep going forward. This, to me, just makes me uncomfortable if we're going to be putting names on a list and then at some point in time saying, well, now that you're on the list, here are the things you have to comply with. But if we're not at that point with these, if these are just on the registry, I'm fine. But I just want you to know that I have concerns.
Councillor Hammond?
Your Worship, thank you. Olivia, I have a two-part question, if you can help me. How do you get to get on this registry? Who makes the selection of these homes?
That would be the summer students. So for right now, me. So we do roadside inventory, and then also anything that is brought to us by, say, the committee, if they have any particular houses that they've come upon, or any owners that have come forward for potentially being wanted to list it on the register. So.
Okay, thanks, Olivia. And the other part of that question is, when you have looked at a home, and these are all built in the 18s and 1900s, do you have to approach the homeowner to ask them if they're interested in becoming a part of the registry?
So we have, let's just get that up. So council, does not require the consent of owners to be listed on the register. However, we think that it may be council's direction that only properties with consent of the owner be considered for designation. So before we had adopted them, we had determined that these 6 were potential additions. We invited them to the public open house for any questions or concerns they might have had. And then that's up to the owner to come forward and ask if they had any concerns, if anybody had objected to it. So we do allow the property owners to give us feedback on that.
Great. Thank you, Olivia.
Okay, so Ms. Ashton, great report again. I know when we initially started the Heritage Committee back up again, we asked these same concerned questions because we didn't want to push people into something they didn't want to do. So I'm glad to hear council still has those concerns and that the public knows it. What I really liked about this one is that in the previous reports is the main focus on the historical buildings has been in the town proper. And I know I was contacted a few times by those who live out in the country area like myself. Well, why aren't you looking at our houses? We've got some beauties out here. So I'm happy to see a number of them being drawn in. And the listing part of it, I understand, it's just, hey, these are some that we should keep our eyes on. And I think the ones that we don't have many actual designated, do we?
No, we only have 4. And since the 80s, we haven't really done any.
And that was more from the pride of the owners saying, yes,
Yeah.
I want this place designated. Yeah. So I assume the same will happen in this case before council gets too carried away with making forced issues. So anyway, great report.
Thank you.
Councillor Dunn?
Through your worship. Olivia, for the registry, the reason why we adopt them on the Heritage Committee is so that we have the opportunity to do some research on them if in fact they are going to be demolished. That's the key report on that, so that it'll come to council. So if anything with significant amount of heritage, we can get a review on it before a decision. We have a timeline limit on that as well. So that's the only reason, and we'll do further research on the property.
Deputy Mayor?
Further to that, and I'm sorry that I'm confused about this because of the report. I'm understanding it. I thought they were designated as well. I apologize. But so you said if they're listed, then we can do research before they're demolished, and then that means we can stop the demolition. Is that correct as well?
So what the listing, so these 6 additions are just going to be listed. So what that essentially means is that it does not prohibit them anything from doing any renovations or alterations to their property, interior or exterior. It just basically means that if an owner were to want to demolish the property, they would give council a notification, and it would be 60 days would trigger. The Heritage Committee would have time to research that property and then present a report to council, and council would make the decision on if they were allowing to demolish or not.
Okay, thank you. And don't get me wrong, I'm all about heritage buildings. I just want to make sure. I feel like lately I've not been asking enough questions, so I need to know this when someone else asks me. So I appreciate the answer. And good on you that you had the answer. Thank you.
Councillor Verbicki, move the recommendation, supported by Councillor Jacobs. Discussion on the motion. All in favor? And carried. Next report is one regarding the application for second dwelling agreement. And Ms. Truax.
Thank you, Mayor Patterson, members of council. Administration has received a request from the property owners of 597 Highway 77 to enter into a second dwelling agreement to allow the existing home on the property to remain during the construction of a new home on that same property. This property is designated rural residential in the official plan. It is zoned A3, or agricultural hobby farm, in the zoning bylaw. It is just over 5 acres in area, and it contains a small greenhouse operation that includes 1 acre of greenhouse range and loading area, in addition to the existing dwelling and accessory buildings. The rear portion of the property is also farmed with row crops. The owners are looking to construct a new home, which is just over 1,800 square feet in area. It'll be located just south of the existing dwelling along Highway 77, and it is shown on the building plan that's attached to the report. The second dwelling agreement is acknowledged in section 312 of the official plan, which allows for 2 houses on one property on a temporary basis upon the issuance of a building permit and a security being collected to ensure the original dwelling is removed. As shown on the building plan, the proposed dwelling complies with the A3 setbacks and zone provisions, as well, the building plan has been reviewed by the Ministry of Transportation, and the owners are aware of the necessary approvals from MTO that must be obtained prior to the issuance of a building permit. In reviewing the application to enter into the agreement, the owners have indicated that it is their intention to keep the attached garage, which is part of the existing dwelling, and obtain the necessary permits to convert that into a standalone accessory building. They've also indicated that they are considering options for future severances in accordance with the land division policies for lands that are designated rural residential. The owners have been advised that further consultation with both MTO and the municipality would be required prior to the submission of any severance application. The recommendation to council this evening is to approve and authorize the execution of the second dwelling agreement with the owner of 597 Highway 77 to permit 2 residential dwellings for a period of 1 year from the date of the issuance of a building permit.
Thanks very much. Questions? Councillor Dunn?
Through you, Your Worship. Danielle, they've applied for a severance to sever the farm from the piece of property. Is that what you said in this report?
No, right now they're just looking to build a second house, but they have indicated that they're considering that as an option in the future.
That's what I meant, considering. My question is then, if they could, if they do separate and take out the house, at some later point in time, are they allowed to keep that other house on that farm if it's a separate property?
Yes, so this is a rural residential designation, so a little bit different than the agricultural land division policies that we usually consider here at council. So they would be able to, if the timing's right, they'd be able to keep the existing one or build a new one if they were to sever.
Okay. Councillor Jacobs.
Thank you, Worship. This might be an off-the-wall question, but anyway. Would this farm operation, looking at it's not a huge farm operation, but I don't know if it's proper to ask, would they employ migrant workers at this specific location? Would you be aware of that? And I'll go one step further, maybe it'll clarify what I'm saying, because we're having a housing situation with migrant workers. And looking at the site plan here that's presented, the proposed dwelling is quite a distance from the existing dwelling there and so forth. Like, could we not make exceptions to some of these until we have a permanent solution in place to leave these second dwelling, if it could be utilized to assist with their labor issues for the short period of time? Is that a possibility, or am I off the wall here?
So initially, the applicants did come in with a request to convert the existing dwelling into farm help dwellings, so they did consider that. We've been working with them through the site plan process to be able to accommodate that. It could still be one of their options if they have if the home is constructed and they've dealt with. There were just some items that needed to be addressed through site plan if they wanted to keep both of those dwellings. So entrances onto the highway, lot grading, those types of things. So the second dwelling agreement really affords them time to be able to construct before the winter. Then they would have that 1 year to either look at the items to sever or to keep the existing dwelling and convert it for greenhouse help. As part of having a second dwelling permanently on the property, as part of the greenhouse operation, they have provided us with justification, details about the nature of their operation. It is small, why they would need help, how much help they would need. So they've looked into that option as well, and it remains available to them if they want to do that.
I thank you for that. Like, I was curious because I know we're all fighting with this housing situation, and I just thought that might be a temporary relief for us. So thank you. That's very interesting.
Yeah. Councillor Verbeke.
For the mayor, thanks. I think we should be consistent. We've done this in the past, so I'd like to move this forward.
Support by Councillor Wilkinson. I agree. We've done this several times, and it works just famously, so good idea. Any further comments, questions? All in favor of the motion then? And carried. Next report is one regarding the disclosure of expenses excluded in accordance with Ontario Regulation 28409. Miss Wu.
Thank you, Mayor Patterson and the members of council. So administration submit this report is to request the PSAP compliant budget be approved and the Ontario Regulation 28409 budget be received. Leamington's 2018 council approved budget is prepared on a modified cash basis, which is a balanced budget which include all of the expenditures and revenues for the taxation year. In order to meet the requirements of the Ministry of Municipal Affairs and Housing, each year administration restates the budget to present it in two additional ways. So one is PSAP restatement, which is on a full accrual basis to match the financial statement accounting. The presentation follows the Canadian rules of the Public Sector Accounting Board, or we call PSAP. And the other way is on the basis as required by Ontario Regulation 28409. The three budget presentations for the 2018 year are shown in Schedule 1. The first column is council-approved budget on a modified cash basis. The budget expenditures match the budget revenue, so there is a zero surplus. Second column complies with the rules of the Public Sector Accounting Board, which means it is prepared on the same basis as the audited financial statements. This presentation method results in a 14 million surplus. Third column meets the requirement of Ontario Regulation 28409. This presentation method results in a 24 million surplus. Schedule 2 shows the changes from the council-approved budget to the two other budget presentations. For example, under the PSAP compliant and Ontario regulation budget, capital revenue is recorded in the year that the revenue is used for capital project. However, in the cash-based budget, the revenue is recorded in the year that the fund is received. For example, we budget a grant revenue for a sewer project in 2018. The project might not be complete until 2019. Grant applications are submitted quarterly after the work is done. So the 2018 third and fourth quarter grant funding may not be received until early 2019. Under PSUP and Ontario regulation budget, the revenue should be recorded in 2018, but under cash-based accounting, the revenue should be recorded in 2019. Debt payments are treated differently as well. The council approved the budget records the principal portion of the debt payment as an expenditure, but the PSUP compliant and Ontario regulation budget record the principal portion of the debt payment as a reduction of the long-term debt liability. Another example is asset purchases, like the purchase of a truck. The truck purchase is recorded in the council-approved budget as an expenditure, but the PSUP compliant budget records the amortization expense, which might be 1/7 of the purchasing price as an expense in 2018 if the truck has a useful life of 7 years. The entire regulation budget does not record the purchase price or the amortization as an expense in 2018. So administration requests that PSUP compliant budget be approved and that the entire regulation budget be received. Thank you.
Thank you very much. Councillor Rubicki?
Through the mayor, thanks. I'm going to say good report because I know how you guys like numbers, but I guess I want to ask a question. I don't see no minus signs in here. So if you see a number in brackets, that's a good thing?
The brackets,
That is a
'cause you-
surplus?
yes. Yeah, so we can say that's a good thing. So in accounting, we record revenue or the surplus as a credit. So that's where you see the brackets.
Then again, saying what you said before, so some of these projects that were budgeted, but you're counting that money in there, that's not a surplus of money that we're going to need next year to finish this project? I know what I want to say, but it's not probably coming out right. So like say the sewer was $2 million and we only used $1.5 million this year. Would that 500,000 be in the brackets here, or did you put the whole $2 million in for sewers?
Well, it depends what the 2 million come from. So if the 2 million is all come from the taxation revenue, and yeah, it is in the brackets.
Okay.
If part of the 2 million, let's say 1 million come from the reserve, then it won't be,
It won't show.
yeah, it won't show.
Okay. Thank you.
You're welcome.
Councillor Hammond?
Your worship, thank you. Woo. I'd like to take you to other adjustments, number 8 on the list. That's on page 33 of our report. It talks about change in post-employment benefits. Does that deal with potential future increases in retirement benefits for our employees? Is that what that refers to?
Yeah, we can consider that. So we have a schedule that every let me say every 4 years, or we have actual report that is done from the consulting company. So they give us a schedule for the focus of the benefit obligation. So based on that schedule, we record our portion to meet the
Expected.
yeah, the future expense we're going to need.
Great. Woo, thank you very much.
How much longer do you have to do these comparisons? And not just go straight PSAP, or do you have to continue using the other one?
Sorry,
How many more years do we have to do the comparison between the cash system and the PSAP system?
oh,
Forever? Forever? Oh,
it
okay.
depends if we're going to change our budget, the way of the budget.
Okay, no worries. I ask the same question every year, because, anyway, it just gets a little confusing for everybody when we're having to compare one way to the other way, and, but the report was as clear as you can make it to all of us, I'm sure. So, thank you.
Thank you.
So we do have recommendation before us. What are council's wishes? Councillor Dunn move, Councillor Hammond support. Discussion on the motion, all in favor? And carried. The next report is one regarding the overview of city works and bylaw enforcement. Ms. Horton?
Thank you, Mr. Mayor. So as you indicated, the purpose of this report is to provide an overview of city works and an overview of bylaw enforcement, particularly as it relates to the uptown. So CityWorks is software which is used by many local municipalities to record, dispatch, and track non-emergency service requests or requests for bylaw enforcement. So CityWorks request may be made online on our website, in person with a customer service representative at our front counter, or over the phone, again by calling in our main number and speaking to a customer service representative. When that happens, the request is received and entered into CityWorks. So the CSR will enter the caller's name, the caller's address, and phone number into that database. We'll record the incident information, the address, the location, and the details of the property, and the details of the incident. So in this case, there was some junk on the front lawn, some brush and trailers on the property. The request is saved into CityWorks. It generates an ID, and that ID number is provided to the complainant. The request is submitted to the manager of bylaw enforcement in this case. In other cases, when it's being utilized for other services, it might be submitted to the public works supervisor or to the building department. The manager of enforcement dispatches the request to an officer, and then typically the officer would go out and inspect the property. The officer can also add attachments such as pictures, work orders, and any other documentation. Sometimes emails might be received, or in this case, there was a property standards order that was issued, so that is saved right into the CityWorks database. All of the comments are entered by those enforcement officers or the CSRs. Some comments are for office use only, so we have a specific drop-down menu that will indicate that it's for office use only, so that is not disclosed. In the event that the complainant calls and asks for an update, the CSRs will know what can be disclosed and what cannot be disclosed. After the final inspection, the officer closes the CityWorks request, and it shows as closed on our records, and that request can be reopened if needed. So that is just the brief overview of how CityWorks actually works internally. Also on our website portal, there is a frequently asked questions document. So if anybody has specific questions about CityWorks, those FAQs are located right on the website through the portal, and it's also attached as the first appendix to the report for your information. So the balance of the report will provide council with information specific to bylaw enforcement, but as I indicated, CityWorks is utilized by most municipal departments now, and I've just provided the specifics of those departments and what they utilize CityWorks for in the second appendix. So you'll see in that appendix, bylaw enforcement, there's a number of drop-down menus in CityWorks related to bylaw enforcement, and those are listed on the last page of appendix number 2. So we canvassed all of our departments that use CityWorks and asked for some of their comments about the benefits of it for their departments. So some of the feedback that we received was that things that those departments have heard also from the public. They've heard that callers have their information taken immediately rather than leaving a message, and that they saw as a benefit of CityWorks. Officers, inspectors, and supervisors have the opportunity to spend their time investigating or undertaking the work rather than returning those calls or taking the initial information that is taken by our CSRs. Their notes can be directly input into CityWorks rather than handwriting into a notebook, so it's a time saving. Calls are identified. More information can be easily added in the comments section, as you saw in those the CityWorks PowerPoint. Callers can request a status report at any time from a CSR. The search of a property address within CityWorks generates results of all calls and issues relating to that address. Photos, emails are easily consolidated and viewed and accessed in one electronic database, rather than going through a number of departments looking for that information. And there's one access for all files, which might otherwise be in hard copy and not accessible when needed if somebody has them in their office and you don't have access to that. And CityWorks can also be used and accessed via mobile device. So our CSRs and other staff who utilize CityWorks have advised that the feedback from the public is largely positive. Residents like the fact that their request has been noted in our system and that they can call and find out any updated information. They like that they receive that request number in order to do so. They appreciate that they can fill out a form online through our website, but they also like that they can come in and speak with someone in person or over the phone so that they have options. Most people are satisfied that they speak with a customer service representative taking their information versus having to talk to someone in the department. And they feel like someone has heard their complaint and will do something about it. We have received some negative feedback too, however, it's not in regards to the CityWorks system itself. And I generally summarize those, the negative comments in 2 points. The speed with which action is taken or results achieved based upon the request for service. Some feel this process is too long or have the expectation the issue should be resolved immediately. We have noted internally that notes are sometimes not updated in CityWorks. And of course, if notes aren't updated, CSRs cannot provide a caller with up-to-date information. We have addressed that issue with all of the departments that utilize the system. Users have been made aware of the importance of ensuring that their notes are updated so that everybody, including the complainants and people that call in for status reports, can have that best, most up-to-date information. The second issue is that no one has contacted a complainant to further discuss the request or complaint. As I indicated, one of the benefits of CityWorks is that officers or inspectors or supervisors have the opportunity spending their time investigating or working out in the field rather than taking those calls for service or requests for updates. However, if a caller does wish to speak directly with an officer or an inspector, there is a tag within CityWorks that can be used to note that a request for follow-up has been requested. But what has become apparent through some review is that that tag doesn't easily come to the attention of the officer and inspector. So we have reviewed the issue and are determining how to better highlight that request for a call back to ensure that request is received and that that call back is made. So as far as an overview of bylaw enforcement, I can advise that officers are responsible for the enforcement of several bylaws passed by council. And I have provided the statistics related to requests for bylaw enforcement over the last 2 years. Now, this is not specific to the Uptown. This is requests all throughout the municipality. In 2017, there were 588 requests for bylaw enforcement. And to date, in 2018, actually to August 20th, which was the date of the writing of this report, there were 592. So officers do not investigate matters that are criminal in nature, such as allegations of prostitution, drug trafficking, activity or use, the unlicensed sale of alcohol. They do not investigate matters that are enforced by the Windsor-Essex County Health Unit, such as the smoking bylaw and food handling. Other matters that are under the jurisdiction of the Ministry of the Environment, Conservation and Parks, such as emissions from industrial uses, normal farm practices, or the determination as to whether an activity is a normal farm practice, such as within the jurisdiction of OMAFRA. Also, bylaw enforcement officers don't inspect for building without permits or contraventions of the fire code. These matters are referred to those departments. So lots of times we get calls in the bylaw enforcement department looking for something to be done about matters that are outside of their jurisdiction. So generally those officers will refer those callers to the appropriate organization. But sometimes we do actually just dispatch those internally through City Works to other departments. So as they relate to the general appearance and use of properties, which are generally the calls that we receive regarding the Uptown, requests for enforcement most often relate to bylaws, which I have summarized in this report. So the first is the Property Standards Bylaw. The authority to pass a Property Standards Bylaw comes from the Building Code Act. And the Act specifically authorizes the municipality to pass a bylaw prescribing standards for the maintenance and occupancy of property. The standards are set out in the municipality's Property Standards Bylaw. The requests for enforcement under this bylaw mostly relate to the presence of refuse, garbage, and dismantled or abandoned vehicles, but complaints are also received regarding surface water in yards, or the dilapidated exteriors of buildings or accessory structures. The Property Standards Bylaw also includes a large section related to the interior of residential buildings, and requests for enforcement of these provisions are generally made by tenants. If a property is not in compliance with the bylaw, the Act requires that an order be issued to the owner. And the Act also indicates that an owner be given 14 days to appeal the order to the Property Standards Committee. So just by virtue of that, an owner would have 14 days to remedy the contravention, in addition to any time required for service. So if that order is sent by mail, there's a 5-day period for that notice to be effective. If an owner appeals the order, a meeting of the Property Standards Committee is held. The committee hears the owner's appeal and evidence from the bylaw enforcement officer as to the nature of the contravention. The committee may confirm, modify, or rescind the order, or extend the time for complying with it. There is a further appeal to the Superior Court of Justice from any order of the Property Standards Committee. If there's no appeal of the order, it's deemed effective and enforceable, and the municipality may take those further enforcement steps. The greatest tool that the municipality has is to go in and do the work required, and the cost is then applied to the tax roll. And although those costs are added to the tax roll, in many cases, they aren't immediately recoverable, and they're only recoverable upon a tax sale or the sale of the property or a mortgage, so that the owner is required to pay off the taxes before that can happen. The process can take up to a number of months, depending upon the complexity of the issue and the time required for a hearing. Generally, if somebody attends a property standards hearing and has legal counsel, there is some scheduling difficulties. If it's apparent that owners are willing to voluntarily bring their property into compliance and are taking reasonable steps to do so, then enforcement officers will monitor that activity to assure completion. If we hire a contractor through the municipality, there is further delay. Sometimes that would be required to go through a tendering process if it's going to be very costly. And of course, that cost places an added burden upon the property that the owner may not be in a position to absorb. The next bylaw is the land maintenance bylaw, which is passed under the authority of the Municipal Act. Land maintenance complaints generally relate to lawn, grass, and weeds, and are generally deemed to be a little less complex than ones that we might proceed with under the property standards bylaw. In this case, if a property is not compliant, an order is issued to the property owner. There are no opportunities to appeal under the land maintenance bylaw. If the property is not brought into compliance, again, the municipality may enter onto the property and complete the work, and the cost is added to the tax roll. Orders issued under the land maintenance bylaw are in effect for 1 year, and an officer can then go in again and do the work within that 1 year time frame without having to provide any further notice. And again, if the owner is willing to voluntarily bring the property into compliance, then the bylaw enforcement officer would monitor that work being done to ensure it's done in a reasonable amount of time. Again, I provided some statistics which are municipal-wide. In 2017, there were 184 property standards or land maintenance orders, and to August 20th in 2018, there have been 182. We started tracking orders that have been issued under bylaws in March of this year. So I don't have the statistics within CityWorks for 2017, but from March 2018 till August 20th, there were 14 orders issued. I did receive some information from our finance department that indicates in 2017, 13 property standards or land maintenance orders were issued. At least that number were issued and enforced by way of doing the work because we recorded the cost. So there was $9,000 worth of work done in 2017, and $3,000 of that remains outstanding. And in 2018, we recorded 6 times where work was done for a total of $5,000, and all of that is currently outstanding. In 2017, there were 6 appeals to the Property Standards Committee from orders, and 2018 to date, there have been 4. So the Municipal Act also authorizes municipalities to pass bylaws respecting signs. Prosecutions of offenses under this bylaw can be commenced under the Provincial Offences Act by the issuance of a ticket. And the municipality can issue tickets when there have been set fines that have been approved by the Regional Senior Justice. In that case, if a person receives a ticket, they can choose to enter a guilty plea and pay that set fine by mail or in person, or enter a plea of not guilty and attend court for the purposes of a trial. If there is a trial, the onus is on the municipality to prove the contravention of the bylaw beyond a reasonable doubt, so it's to a criminal standard. Evidence is generally required to be given orally, and a conviction results in a fine. This can take a number of months depending upon the trial coordination. It is an effective tool of enforcement. However, officers have been largely successful in obtaining compliance by providing business owners with applications to obtain the permits for their signs that may have been constructed without a permit, for businesses without signage or inappropriate signage and properties with abandoned signs. The bylaw does authorize the municipality to remove signs erected in its contravention, and officers do so regularly. I have the stats for the sign bylaw enforcement requests. There was 27 in 2017 and 22 in 2018 to date. And then again, the orders from March to date were 2. As council is aware, one of the most serious issues affecting the uptown is the leaving of garbage on the sidewalks next to the municipal trash receptacles. Prosecution of offenses under the waste bylaw may be commenced under Part 1 of the Provincial Offences Act, again through the issuing of a ticket, same process that I talked about before. Although it may be an effective tool of enforcement, identifying the people who are contravening the bylaw is difficult, and proving the identity of an accused is an essential part of the prosecution's case. As the goal of enforcement is stopping the offending activity, officers have on several occasions picked up and gone through the bags of garbage and have confronted suspected offenders, and it does appear to be an effective deterrent. Since bylaw enforcement and public works staff have worked jointly together to deal with the issue, public works staff have reported that there has been a reduction in such activity, and these departments will continue to work together to confront and educate suspected offenders. I do have uptown specific information because we do have a specific City Works drop-down menu for uptown garbage requests. We had 7 in 2017 and 5 to date in 2018. The authority to pass a zoning bylaw comes from the Planning Act. The most common requests for enforcement under the zoning bylaw arise out of the use of lands, but other issues such as the height and location of fences, the number of driveways, and the location of accessory structures also trigger complaints. Prosecution of offenses under the zoning bylaw may be commenced under Part 3 of the Provincial Offences Act. That means that information must be laid before a Justice of the Peace in the Ontario Court of Justice. So an officer attends a court, in that case, swears to the truth of the evidence submitted, and a Justice of the Peace determines whether there is sufficient information for a charge to be laid. The accused in that case would be required to then attend court after being served with a summons. He or she would enter a guilty plea or a plea of not guilty and proceed to trial. Again, the onus is on the municipality to prove the contravention beyond a reasonable doubt. A conviction would result in a fine, and it can be, again, a lengthy process. In cases where the issue is the use of lands or buildings, the preferred option is to commence an application to the Superior Court to obtain an order prohibiting the use. Court order may also require the defendant to take certain steps to remediate the property and provide the authority to the municipality to take those steps if the defendant fails to do so. The municipality would be required to provide evidence sufficient to establish on a balance of probabilities that a contravention exists. So it's a civil standard, so it's a lower standard of proof. And the evidence may be submitted by way of affidavit. The municipal costs may be ordered to be paid by the defendant if the municipality is successful, but conversely, if the municipality is not successful, it may be required to pay the defendant's legal costs. Process, again, is lengthy, and depending upon the complexity of the issue, it could take up to a year. It's noted that the proceedings based upon the contraventions of zoning bylaws are often complicated by property owners asserting that the use is legal non-conforming. So municipal-wide zoning bylaw service requests in 2017 were 34, and in 2018, 32. 3 orders have been issued since March. Again, in this case, when there's bylaws relating to buildings and structures, there's some overlap between the building department, the fire department, and bylaw enforcement. So in order to obtain evidence, In an effort to determine if there is a breach of a bylaw, an officer will need to access to lands and buildings. Generally, entry upon lands is authorized by bylaws and legislation, and in some cases, though, owners of properties may not wish to permit officers or inspectors entry and may obstruct that entrance, especially when it's entry into buildings, not just land. There's no legal obligation for a property owner to allow entry. If an inspector or an officer is denied entry, he or she must obtain a warrant. So I summarized the law regarding entry into buildings and onto land. So there's three pieces of legislation that apply generally, and that's the Fire Protection and Prevention Act. The FPPA indicates that a fire inspector may, without a warrant, at all reasonable times enter and inspect lands for the purposes of assessing fire safety. So the difference between the FPPA and the other legislation is there's no indication that there's any differentiation between a dwelling unit and a non-dwelling unit. So this piece of legislation does contemplate that an inspector may be denied entry or obstructed. So there is a provision for a justice of the peace to issue a warrant authorizing that entrance. The warrant would be granted if there's reasonable grounds to believe that it's necessary to assess fire safety and that entry has been or will be denied. In the event that a warrant has been issued, and only in that case, does an inspector have the right to use force to enter a land or premises. Under the Building Code Act and under the Planning Act, an officer or an inspector may enter without a warrant, and there has to be consent, specific consent, if the unit is used as a dwelling. If there is no consent, then, and it is a dwelling, he or she must obtain that warrant, or if there's any obstruction or refusal of entry, he or she must obtain a warrant. There's no right to use force. And again, in this case, to obtain a warrant, reasonable grounds must exist, and it must be granted by a justice of the peace. So in the case of both the Fire Protection and Prevention Act and the Building Code Act, there are provisions to enter upon land without a warrant in cases of immediate danger, and that's even if the premises is used as a dwelling, but then there's specific steps that must be taken after the fact. So as I indicated, there has to be sufficient evidence in order to proceed with the prosecution of a bylaw contravention, whether it be to the criminal standard or to the civil standard. The amount and type of evidence will differ depending upon the nature of the bylaw, infraction, and the form of the prosecution. And I did provide an example in the report of an application to the Superior Court for an order prohibiting the use and occupancy of a building. In that case, there were 10 affidavits of staff and third parties, which were prepared and sworn. They had exhibits attached, including orders issued by the building department, the fire department, and the electrical safety authority. Well over 40 photographs, probably from at least that from each department. Correspondence, corporate profile reports, excerpts from bylaws and other municipal documents. The investigations into the circumstances of this occupancy were spread over the course of 10 months. Supplementary evidence was submitted consisting of 5 further affidavits with photo exhibits. The hearing into the matter was before the Superior Court. It was originally scheduled for August 22nd of last year. After interim orders were issued and further attendances before the Superior Court, on October 24th, 2017, a final order was issued on consent of the parties. So that means there was no determination on the merits. The defendant agreed to the order that was submitted to the court. And that defendant did have legal counsel in this case. The matter of the condition of the building and the viability of its remediation is ongoing, so that wasn't the end of the matter. The matter continues on. A very conservative estimate of time that staff involved spent in connection with the matter is at least 125 hours. So I do speak to one specific concern related to a matter that is not currently regulated. There have been a number of requests that the municipality pass bylaws related to the covering of windows of commercial businesses, particularly in the uptown, and specifically regulating the percentage of the window that may be covered, as well as, excuse me, the type of covering that might be used. There are currently some properties with commercial uses that have erected window coverings that are not aesthetically pleasing for the purposes of which are unknown. Regulations regarding window coverings raise a number of issues. First, one must consider some of the reasons that windows may be covered. So I listed those: during construction to hide from public view the unattractive construction activities. If there's legitimate personal services being carried on inside, it may be appropriate, and if not mandatory, that customers be afforded that privacy. If documents and records of the business are private and confidential and may otherwise be viewed through an uncovered window, and the blinds need to be closed to protect the interior from the sun. However, there may be a public safety argument to limit the covering of windows to a certain percentage, but the argument needs to be based in fact. The municipality has limited authority also to impose standards upon the interior of a property unless they relate to health or safety of the occupants. So prior to drafting regulations relating to window coverings, administration recommends consultation with the public, not only the BIA and other business owners, but customers, the OPP, and residents. Consultation would be for the purposes of obtaining the opinions of the parties regarding the necessity to regulate window coverings, collecting that factual data to support regulating the percentage of windows covered for safety purposes, obtaining suggestions as to the types of coverings that may be permitted or prohibited. Those facts would support the rationale for passing such a bylaw and would provide the necessary factual basis to defend any challenge to it. So a further report would be brought forward to council following this consultation and include recommendations regarding such regulation. As was indicated during the 2018 budget deliberations, bylaw enforcement officers and other members of staff do undertake some proactive bylaw enforcement within the uptown. To assist with all enforcement activities since June, bylaw enforcement officers have worked most Saturdays and Sundays, and since July have worked at least until 8, between 1 to 3 times per week. Enforcement officers meet weekly with the director to review the status of investigations and as needed throughout the week, and officers meet as needed with the municipal lawyer to review further prosecutorial measures that may be taken. Despite the ability of any person to contact the municipality to request bylaw enforcement, there is an apparent reluctance of some to do so. Also, it would appear to be a perception based on social media comments that there should be no requirement that requests for bylaw enforcement be made by the public, but rather that staff should be proactive to enforce bylaws. If council were to direct proactive enforcement of bylaws within the uptown, the goal of such a project would be to improve the visual appeal of the uptown through proactive enforcement of the property standards bylaw, land maintenance bylaw, and sign bylaw, and continue to work with Public Works to deter contraventions of the waste management bylaw. The assigned officer would also be responsible to educate uptown business and property owners and residents about the provisions of these bylaws and their responsibility to comply with the same, as well as the business licensing bylaw and zoning. The officer would further provide information about the municipality's CIP and direct business owners to the municipality's Economic Development Office in this regard. Although appealing from a customer service perspective, proactive enforcement does create 2 possible complications. Immunity against liability for non-enforcement of a bylaw rests upon the decision of council to employ a complaints-based or a reactive system of enforcement, meaning that council has made a policy decision to enforce bylaws only upon request. This decision is based upon Section 450 Sub 1 of the Municipal Act, which indicates that no proceeding based on negligence in connection with the exercise or non-exercise of a discretionary power or the performance or non-performance of a discretionary function, if based upon a policy decision of a municipality made in good faith, shall be commenced against a municipality, a member of council, or an officer, employee, or agent of a municipality. Therefore, rather than being at risk of criticism for employing a reactive enforcement, the municipality may be at risk of litigation alleging negligent proactive enforcement. Proactive enforcement decisions will also be scrutinized for evidence of selective enforcement, which may result in arguments that the municipality is acting in bad faith. There are no financial impacts arising out of this report except those related to a proactive enforcement pilot project. The financial impact of such project would be associated with any claims for negligent enforcement that may arise during the term of the project. Although most claims would likely be insured, the municipality's deductible is $5,000 per occurrence. Claims history is a significant factor considered by an insurer when determining whether an increase in the municipality's premiums is warranted. Further financial impacts associated with any regulations related to window coverings or any continued proactive enforcement will be addressed in the next reports if council provides such direction. So the recommendation is twofold. The first is that council direct administration to undertake public consultation related to the regulation of window covering. And the second contains two options. The first option is that council direct administration to maintain reactive bylaw enforcement within the uptown. The second option is that council provide direction to administration to commence proactive bylaw enforcement in the uptown as a pilot project and assign a current bylaw enforcement officer specifically to this project, and that administration bring forward a report in connection with the impact of the project prior to the 2019 budget.
Thank you very much, Ruth. Comprehensive report. So, questions from council to Ruth? Councilor Verbicki?
Where the mayor, thanks. I guess a couple questions is, people do not like to call in. They say they elected you and they want you to do it. It's hard to believe in this day and age, but north of the bypass, there are still people out there with a rotary phone. I just want to know, it doesn't seem to be working when you need it to work. There's some issues out there, and I just want to know, why can't elected people work on the behalf of their constituents?
Are you asking why you cannot call on behalf of a resident and submit that request on their behalf? You can.
Yeah, but I don't want to be named in a Freedom of Information Act, because I've been through that already. And so it can be done then?
Yes.
Thank you. And also, I know that the bylaw officers, when I come in, especially with the noxious weeds, have been very proactive. But there's some more coming out there now. Do we still come in and talk to the people, or is our weed inspector going around checking it out, or are we still basically reactive on this instead of proactive?
I'm going to have to defer to my colleague on the inspections of the weed inspector.
Okay, I'm just throwing it out there, just so that's, I don't want to say a follow-up, just maybe inform us all, with a quick email.
I will have to follow up on the actions of the weed inspector.
And there you go again. My final question, worthy mayor, is everybody wants to know how come it takes so long. Somebody makes a call, depending on the severity, I'm assuming, but I see now our faithful employees are now all issued bulletproof vests, which is blowing my mind. Some of these incidents are tough to go through, but I'm just, people changing motors in alleyways is one. It took a long time to get rid of a car. I don't know. It's just, I guess every case is different. I mean, I see you still have 3 open up from 2017. Now, is that still? And then you say it has to be a year process. So I'm assuming that they're at the end of the year. But I just, everybody wants. I come here, the computer's fast. I go home and it's a little bit slower. So everybody wants speed. So there's no timeline specifically for. I get 72 hours. And, everybody wants the phone call back. I guess that's another thing, too. If people call back and want to know the status of their PIN number, they seem to leave messages and nobody returns their call. And then also, but they're out in the field working. I'm not criticizing the staff. I'm just saying, they're busy, but it's a common courtesy. How long does certain things take? I mean, you can't put a timeline on a car with flat tires with no license plates as opposed to a car with the motor out, as opposed to now our bylaw that we have with the cars parking in front of their house, which never seems to end up. And I know we have some bad repeat offenders there, but it's just, it's not working. For me, it's not working. I know Councillor Wilkinson's happy now that it's online, but a lot of people don't like that. I don't know. That's my opinion, and I'm speaking on behalf of some of the people that have used me to be the go-between, which sometimes bites you in the butt.
A lot of questions in there.
Yeah, I'll stick to the highlights, I guess. If there are people who do not wish to make the call, my preference, and they'd rather go through a member of council, my preference is that the member of council at least relay that information through CityWorks so that we have it and we can act on it, rather than people just being upset that nothing's being done. If the request hasn't been made, then we aren't aware of it. So I want to assure you that that is the preference, rather than no request being made at all. As far as being concerned about leaving your name, names are not disclosed even through a Freedom of Information request unless ordered to do so, or unless required as a witness in a trial. At that point, the person who made the request may be summoned to provide evidence if it's the only way that the evidence can get in before a court. So those would be limited circumstances. As far as the speed within which things are completed, I can say that we do our very best to try to resolve issues either voluntarily. That's usually the preferred approach, and if it's reasonable and we believe that there's going to be reasonable compliance within a reasonable amount of time, then we will react that way. As you indicated, sometimes things do take longer than others, depending upon the facts, and sometimes we haven't done well. I will admit that we can always do better, and we are always working to do better. So please feel free to convey that to your residents. It's best if they call in that their names will be protected as best that we can under the legislation, because they are the ones that actually see the things happening and can probably give us the best information. As far as calling back, the system is really designed, and that was one of the reasons that we wanted to implement the system, for our customer service representatives to be that conduit for information, so that our officers, our inspectors, and our supervisors can be out there doing the work, rather than on the phone taking the information that can be taken by a third party and relaying the status that can be relayed by a third party. We understand, though, sometimes there are cases where those callers may want to speak to the person who's acting out there in the field, and we can understand that. So we will return those calls, but sometimes those people have a number of calls on their phones too, and it takes some time to get back. And we are looking at that frailty in the system that we did identify, and hopefully we can find a much better way to respond.
Okay. Councillor Wilkinson next.
Thank you, Worship. First of all, I want to start out by thanking our staff that came here tonight. Our bylaw officers are back there. We got our ladies here that'll be here for our next report, City Works. I really appreciate you coming out. I think it shows volumes, your character and commitment to your job that you're here tonight. I don't think you had to be here, but you are. So thank you very much for coming. I got a number of questions here. We'll probably be going back and forth a little bit here over the next little bit. First is in regards to City Works, a program that I'm glad we have it. I think it's a great piece of software that we have, great piece of infrastructure for us to use for so many different reasons. I'm glad we invested in it, and I hope that we continue to improve upon it as good, worthy suggestions come in. I hope that that's always like a living document, that this thing gets built upon and improved upon. But this first question that I have, this one was given to me earlier on in the City Works, and I just wonder if it's been repaired since. People were saying, what if a person loses that tracking number they're given when they call in? Has that since been rectified, that if I don't have that, if I lose that number, can I get an answer over the phone that day?
Yes, I see the potential for that. So if a caller just asked, I called in on this date about this address and my name is, there's the capacity to search for it.
Right.
Yes.
Okay. I've heard those complaints in the past, and I had one instance too where I called in, I didn't have my number with me, and it took quite a while for them to find it. And I wonder if they were going to find it if they wouldn't have known that, as a counselor. So I kind of, but eventually it was found. But I have heard that complaint on a number of occasions. They don't have that number. They don't get an answer then. So anyway, I'm glad to hear that that's, anyway. In the report here, it's mentioned on page 40 that, and I'm glad you described this. Let's go back to page 40. If you notice suspicious, let me go back to my page here. By law enforcement officers do not investigate matters that are criminal in nature, such as allegations of prostitution, drug trafficking activity, and the unlicensed sale of alcohol, or matters are enforced by the Windsor-Essex County Health Unit. Now, we got a number of the usual suspects around town that we're constantly sending our guys out to look at, If we're sending them over there for, let's say, parking matters or illegal cars, and they get back to me with an answer saying, hey, they're within compliance. But I've mentioned it a number of times in my reports, after talking to the neighbors of close by, the affected neighbors uptown, they're positive shady stuff is happening. And that's been my exact words a few times in my city work reports. Are we proactive then? Are we working with our municipal law enforcement people, our health officials? Are we dropping a line into them to let them know? Looks like everything's complying on our end, but we're pretty sure there's activity happening here. Lots of times it's at night. I've sent you guys for parking reasons. Doesn't look like anybody's in that building during the day. At night, there's a lot of cars parked there. Windows are covered. Looks like there's activity happening there. Are we proactive in that regard of putting it on to law enforcement?
We work collaboratively with a number of organizations, the health unit, the OPP. We have to be cautious of what we can share because we still are within the MFIPA, so freedom of information, we have to keep that in mind as well. So the preference is, in a lot of circumstances, to refer the people that are making the complaints directly to those organizations so they can share that information directly. So I'll say it's a collaborative relationship, keeping in mind what we can and cannot share with other organizations.
Thank you. I look at these guys as our boots on the ground. They're our soldiers on the, front line, and they're probably exposed to the activity more than the majority of us in this room. I hope that if it's within reason that you do exercise that option. Anyway, just a comment. Third, moving on, sign bylaw was mentioned in this report, and I'm glad it was. I got a number of questions here we're going to go into. First one is it mandatory? I got my sign bylaw right beside me here. Is it mandatory that all businesses in the urban area, with the exception of, let's say, in-home occupations, are they required to have a sign?
That is one of the intents of the sign bylaw, is to direct people to the business. So is it mandatory? I'd have to check the provisions to see if there's actually a section that's a set fine is associated with the absence of a sign. We would certainly encourage a business to have a sign, and in keeping with the intent of the bylaw, there could be a potential to, again, I'd have to check if there's a set fine associated with it, but to issue a ticket if one is not there, if there isn't a sign present.
Okay.
Councillor, I just want to mention that this report is on the city works and all that kind of stuff, so try not to go too deeply into the other bylaws that are covered by it.
Sure. The only reason I bring it up is because, yes, it is mentioned in,
Yep.
It's got pretty much a whole page dedicated to it, so I figured this is the time. So back to that, signs then are not, it's not mandatory that they're uptown. Do we know with other communities, do they enforce that signs must be in their urban area?
I'm sorry, can you repeat your question?
When it comes to other communities, like I go into other communities, they're all, majority, it's not often, I don't notice no signs on their building. But yet today, when I drove around, there's quite a number on a page, and I left my notes home with me today, unfortunately. But we got quite a few around town with no signs. That's something I would hope we'd look into, is what other communities are doing, with good practices. Are other communities, are they making their merchants in the urban area have signage? Is that mandatory?
If you want to submit that list,
Sure.
so I can review it and get back to you, and if you put it through CityWorks, if there's a provision, we can certainly set out to enforce it.
While we're on I've got a whole list of things on how I think the sign bylaw could be improved upon. And we've talked about that a number of times. I know the last budget was certainly brought up. It was brought up at a BIA meeting review here. I'm just wondering, it was mentioned in the past that you were going to revisit the sign bylaw. When is that going to occur?
And I do recall that it did come forward with a specific provision regarding electronic signs. And I think the direction of council was to take it back and bring it back before council. So it certainly is on the list of matters to revisit based on that last
But that was just one
provision.
component of the sign bylaw, right? There was going to be, we were going to open up the entire sign bylaw here and dive into it and see where improvements could be made. Was that the intent?
It was not the intent of the last time, but certainly it's one of the many bylaws that we would like, our whole department would like to review. There's a number of others as
Sure.
well.
Because that's the way I've understood it when I've heard that it's going to be re-looked at, that we are going to open this thing up and make a number of improvements. That sign bylaw is pretty Mickey Mouse, if you ask me. I come from the industry. I got many notes on it. I've harped on it since I, first got on the council, that the sign bylaw needs to be improved upon. I hope that happens in the near future. After I read this report, and I read it over a number of times here last night, I basically said to myself, in regards to the recommendations, why now? Actions like this have been begged for by this council. This intensified proactive bylaw enforcement pilot project. We talked about this so many times. This council, our previous council. I looked up last night at the strategic meeting that's online. Our strategic meeting isn't there, but the other council is. And they were talking about the issues in the uptown as well. We've, some of the other times I know we've talked about we needing, our bylaws to be enforced, our property standards to be enforced. We talked about during the hiring of our third bylaw officer. That was a hard one for me to get over and get convinced of, but we had discussions like this, and then I was in favor of it. When we hired Ed, we touched on it. Ed was going to be our guy if we went out and really showed that we were going to make change in the uptown. We were going to be able to defend ourselves with Ed. So I bought into that, and I still support that. I want to be out there being proactive, just like this action is saying. And if we get in trouble, I do want Ed to go defend us. I'm willing to take that chance. We've talked about it at budgets. I know the last two budgets we've talked about it. Discussions at strategic meetings. We talked about it at that BIA forensic meeting we had here just last year about the need to enforce our bylaws and property standards. BIA general meeting, leading up to the City Works implementation. That's 7 or 8 times that I can just roughly recall where we've talked about action that needs to happen. For every time that we get, you mentioned social media in here. I noticed that in your report. Not only social media, it's every time that we go around town. You guys know about running the gauntlet at the supermarket, Tim Hortons, wherever, arenas, baseball diamonds. We get hit up with this stuff. We are the ones that are bombarded with it. What are you guys doing? And often we toe the company line that we've been told the whole time. We are doing everything we can within our power under provincial and federal laws. It's something along the lines that I've heard so many times since I started on council here. So I tell people we are doing everything we can, and it's not despite us not bringing it to our directors, CAO, our senior leadership. We're being told that we can do everything we want. So that's why I ask myself, why now? We have a tool here. We have an action. If you would have brought this to me right after the strategic meeting, I would have said, this is fantastic. An intensified look at, almost setting up a hot spot in the urban area that we're going to go after people in regards to bylaws and property standards. I would have said, that is a project. That's something. Give it to me. Let's go out and try it. Because it's described here as, and this is what we wanted the whole time, would be to improve the visual appeal of the uptown through proactive enforcement of the property standards bylaw, land maintenance bylaw, and sign bylaw, and continue to work with Public Works to deter contraventions of the waste management bylaw. That's exactly what everybody has been asking for, is, go do it. Give us this a better visual appeal that you're talking about, that this project will do. Why now? Why wasn't it brought to us 1 year ago even, 2 years ago, 3 years ago? Now we're deep into the term here, and yeah, we got something for you guys. Here it is. We actually could do more. That's the way it kind of looks to people that I got to face now. When I say, hey, we do have something now, we're going to go implement it. They might say to me, why didn't you do it 2-3 years ago? Anyway, it's hard for me to defend. But anyway, I am in favor of the suggested action. I'd be a fool not to be. This is exactly what we've been wanting. I look forward to the recommendation here about the window coverings. I think that's going to be a tricky one. I do. And I would be in favor of option number 2A, to commence the proactive bylaw enforcement in the uptown as a pilot project. I'm looking forward to hearing what our delegate has to say. I'm looking forward to hearing what the rest of the council has to say. But that's my thoughts on this so far. Thank you.
So no question then? Nope. Okay. So Councillor Jacobs?
Thank you, Worship. I just have a couple of things. Well, first, I'm glad we're moving in a positive direction on your recommendation number 1. And option number 2A is the one that I was wondering, will there be an information period during that implementation of the, using that as a specialty area? Or will we just be going out like a heavy-handed? Like, will we be working with individuals within the downtown core to say this is what we're going to be doing? I guess sort of easing into it type thing?
That was not the intention. I think we would go in and, so the only difference is the officer would be looking for those bylaw contraventions rather than having it being a complaint driven. So the response would be the same as if it was a complaint received through City Works by a third party, but rather the officer would be looking for those issues. So that's the only difference between reactive and proactive enforcement is you don't wait for the complaint, you go out and look for the infraction. So there wouldn't be any purpose to really provide any information sessions that this is happening other than this council meeting, because then the officer would take the same steps that he would have otherwise taken had it been received from a third party.
Okay, I thank you. I guess that's where I was going with this, the fact that I know that we have our appeal committees and so forth, and the officers do work with the individuals in those type of a scenario. But I was wondering, like, will we go in and say, well, you know, there's a bylaw about your window coverings, as an example, that you either need to clean it or wash it or, you know, hang something in it or take something out of it. So I guess that's where I was going with this, the fact that they would work collaboratively with these individuals to see that the proper thing is being done.
Yes, in connection with any potential bylaw regulating window coverings, again, it would be potentially a notice. So the officer would make contact with the owner, like the officers do with any kind of bylaw infraction, advise them of the bylaw. They might not be aware, probably not at that time, and certainly provide them some time to comply before further enforcement measures are taken. There should be plenty of notice if council does move forward with the recommendation regarding the window coverings regulation. We're going to be reaching out to the public to receive that feedback in the first place, so hopefully we get the word out in that regard that we're contemplating something like that.
Okay, I thank you very much for your comments. Also, as your staff is sitting here this evening, I'd like to compliment them. They've got a difficult job that they're doing, and I know that, you know, everybody calls today and wants it done tomorrow. I give them a lot of credit in what they're doing. I know they're overwhelmed. I know anytime I've had interactions with them, they've been more cooperative and, you know, looked after things the best they could within a timely manner. So I'd just like to extend our gratitude to you guys back there too, and yourself as well. Thank you.
Deputy Mayor.
Thank you, Mr. Mayor. Just a couple things. I too am happy with the idea of this City Works. I think that our residents need to get accustomed to the fact of how it operates. I've been taking a number of complaints, if you will, comments probably is the best word, on how the process works. And I think at the heart of it is that we're still a small town and people like phone calls back. And I believe that is the crux of the complaint from, and I'm not talking in the core, I'm talking in the rest of the community. And that's when they call us. So that's why I'm emailing you, is because they're coming to me because they've not had a response. And now that I know there is a tag on there that they can or that they can ask, we'll definitely direct them in that, send them in that direction. I just want to make a comment, and I know this is going on a little bit longer than we thought, but I do think it needs to be talked about when we implement a new process. to me, society has changed. I'm older than you are, but back in the 50s, there was pride of ownership and pride of place. People wouldn't have been caught dead with a long lawn or with peeling paint or with any kind of messy things. That was how society was. And I'm going to say that went well into probably the 1980s. And I'm going to say since then, there is definitely a change in how people take care of their homes, how they take care of their properties. And I believe that that is what's happened with property standards. You know what, I'm not going to say worldwide, but I'm going to say probably North America. People just don't take pride in that kind of thing. There just isn't, it's not seen as a priority. And I think that's why we've dipped to these new lows. And I know you're quoting social media, and I'm certainly not a fan of the comments on there because to me they're generally a bunch of trolls who actually don't want to show their face when it comes to the public. So the rest of us have to deal with their comments. But I'm talking about people that are coming to see me. I've been seeing quite a few people in the last 8 weeks, and the common complaint is the condition of the uptown. And whether we like it or we don't like it, we need to admit that people are not, a lot of people are not taking care of their properties like they did back in the day. And I believe that that is the reason why we need to go from being reactive to proactive. I went to a seminar in Kingsville a couple of years ago on bylaw. I was there with Kyle and Jeff, and that was exactly what they touted to us, that was how bylaw was supposed to be. And I did buy into that. And really, I made excuses after excuses after excuses to uptown that we couldn't do this. I looked up some other municipalities on the internet, and all I did was put in proactive bylaws. I didn't put Ontario, I didn't put North America, but right away, up pops London. London has both. Up pops Belleville. The majority of their bylaws are proactive. Penetanguishene popped up. Anything deemed detrimental to the overall image of their town is under proactive bylaw enforcement. So what I'm seeing here is something that needs to be done just because of the state of society, not particularly the state of our town, but the state of how people are doing business, and we need to react according to that. We are not trying to be a police state, but I do believe we have to have standards. And the majority of people are telling us as council representatives that there is a need for a certain standard. We're not saying every building has to be painted teal blue, every door has to be yellow. We're just saying clean your windows, pull your weeds. When there are broken windows, they need to be fixed. We don't want a bunch of garbage out front. We don't want to have barbecuing going on the street. We want to have safe, decent, and pleasant. A friend of mine who's not lived here for 25 years came to town, and this is a gentleman that probably a lot of people up here will know. He had a very well-known business in the community. He's moved to Toronto and on to other wonderful things. He came and visited us 3 weeks ago Saturday, and he said, "Hilda, your town is looking really shabby." And you know, I've taken it from a whole lot of people and kind of poo-pooed it, but when this gentleman said it, I took it to heart. And I believe we all need to start taking it to heart. It isn't just it's not just the trolls, it's not just the naysayers, but it's people who have loved this town in the past. And if we can't deal with it, then we need to move on and do other work. I'm determined that we return our town to a level that we once had. I'm determined that we set a standard. I'm not for being a police state, but I say we need to set standards and then we need to hold people accountable. I'm not talking fines or anything like this. I'm talking harassing the daylights out of their rear end, if that's what it means. It just means setting an example. Even if it means hiring men in quilts to clean the windows, we need to start doing something. And if that is what proactive is, I'm all for it. Like I said, and I'm going to apologize to the BIA because I actually quit the BIA because I could not give them the assurance that we were going to be proactive. And that's why I am, like Tim, quite surprised that 8 weeks before the election, we suddenly have the ability to become proactive. This, to me, raises a red flag. Where in the heck have we been for the last 3.5 years, minus 8 weeks? should have been done when our strategic planning group met, when we set the word out there, we wanted to be proactive. I'm glad we're moving forward, but I am somewhat angry. I'm apologetic that I said we couldn't do it and find out today or on Thursday night when I picked up my agenda that yes, lo and behold, council can actually do this. I'm for number 2. I think that's the only way we can move ahead, but I am apologizing.
Councillor Hammond.
Your worship, thank you. We've talked about a number of things here. I want to go back just a bit to a comment made by Councillor Verbeek, because in my notes, one of the things that I had touched on with City Works as well is you hear that time and time again. No, I'm not calling City Works. That's why we elected you. You get in there and do that. And I've steered more people than I can dare mention to City Works. But I still hope I've got that ability to, in going through to pick up my minutes or whatever, if I see one of these fellows or, that I can say, listen, if you had a chance to go down to the corner of Erie or something and take a look at I hope you don't stop us from doing that. I don't knock on their door and spend a lot of time with them, but periodically in walking through, I do want that ability to be able to, I don't take a lot of their time, and I think they can tell you that. I just want that ability to be able to continue to do that. And I hope you don't say to us as council, no, we would prefer you steer everything away from that. You don't want that direct contact. So, and you haven't said that, and I hope you don't. Councillor Wilkinson, again, regressing back a bit, mentioned page 40, and I had that highlighted as well, but I took a little different slant to it than what Councillor Wilkinson did. And that is that a lot of people are of the opinion that it's much easier to call City Works than it is to call the local police. People we know don't want to give their names. So I'm going to read that paragraph again that Councillor Wilkinson made. His take on it was, there's so many things that our bylaw people cannot, what duties they can't perform, so do we direct them in the right area? But I want to reiterate the fact that there's things that they're not allowed to do, such as allegations of prostitution, drug traffic activity, unlicensed alcohol or sale of unlicensed alcohol, all of these things that a lot of people think that our bylaw enforcement should be on top of all of these things. Whether it's being a leaky gas pipe uptown or something else, that's the first thing they do is call here and say, well, you better get somebody else there because there's a leaky gas line on Erie Street or somewhere. So I think it's important that we emphasize, and I was glad to see that, Ruth, in the report, and by the way, that's a very comprehensive report. I've gone over it a number of times since Thursday trying to get my arms around it and get my thoughts together. But I too, along with the Deputy Mayor and the comments made by Council, all the comments we've heard so far, we all understand the importance of the revitalization of uptown, not downtown, uptown. And I'm pleased that this is before us now, that we can get a hold on this. I certainly believe in being proactive, not reactive. And whether that requires more bylaw enforcement people or more time, then I guess we're going to have to look at that come budget time. But if we are going to turn around our uptown, I think this is the beginning, and this is what we need to do. I mean, we all know that a lot of the store owners don't want to spend any money in their buildings now, and we offer CIP free money, and they refuse to use it. Every year, we don't even use the allotted amount of money that we can for people to beautify the front of their stores. But maybe if we get turning things around, maybe people will start spending more time and more attention and bringing up some of the points that Deputy Mayor did about their storefronts, and that includes the signs and the waste management and all of those things. So I will close it by saying this. We can do all of these things, but I also think that, and it isn't part of this report, but this is more of something I felt deeply about over the past while, we need a stronger police presence uptown. We need to, and I understand there's a cost involved in that, but we need a stronger police presence uptown to walk these streets and help these bylaw enforcement people who are getting barraged by all of these requests that they really shouldn't be falling on their shoulders, and try to help get our uptown cleaned up. Thank you.
Councillor Dunn.
Through you, Your Worship. First of all, Ruth, I wanted to start off by when we talked about budget, we talked about the bylaw enforcement and having people strictly for the proactive. But is not some of these officers already doing a little bit of proactive? Or is it all just reactive?
When officers are out at a specific property, if they see other infractions in the general vicinity, yes, they will note them and they will follow up on them, but it's not a proactive enforcement program that would be directed by council through that policy decision and direction. But as I indicated at budget, some proactive enforcement does take place. I go out myself, I drive around from time to time, and I note specific violations, and I submit those through CityWorks as any other resident would do. But as I indicated at budget, the majority of those requests are through CityWorks, through the residents, through the uptown business owners, and that has been how we have enforced those bylaws historically.
And then a comment. First of all, I love the fact on number one that you're engaging the BIA and the OPP about the window coverings. I know that was an issue, so I'm glad that we're engaging everybody to start getting those talks to get the right bylaw in place to enforce that properly. When it comes to the proactive, I agree that we need to do more proactive enforcement for the downtown area. Now, in the case of this, so the CityWorks that's already operating, are we going to all that go on to 2 officers and one just going to be directed to be proactive in the downtown area?
If that's council's direction, we'll have to look at how we're going to allocate his time. I anticipate that it would be likely the majority of the workday would be associated with that. It's going to have to be something that we have to determine. That would leave the manager and one other bylaw enforcement officer. So the report at the end of any pilot project would address how that time was spent, how effective we think it is, measured as to how many requests have been submitted through that officer as a proactive enforcement officer, and how it impacted the balance of the time of the other 2 and the time within which we can respond to the requests from outside of the uptown.
Just and further to that, so because my thought is this, so it could cause extra delays on the CityWorks stuff then, so that they go further behind on people that are calling in, unless it's directed to the uptown, or these are questions that just popped into my head. I'm sorry.
I would anticipate that may be an impact, yes, but we would certainly address that at the end of the day in the report as to what kind of an impact it was.
And then further, Your Worship, just a comment that I know that we've done quite a few appeals from these different people. I know there is a process that you go through, the waiting period, and I appreciate all your hard work. But what was brought to my attention from administration about previous, that the number of appeals that are coming to us because of the amount of enforcement was very minute. This has been hit a lot harder. Yes, I know we do need to improve still on the situation, but I know that there's a lot of work being done, and I know we're constantly having to find meetings and time to get meetings to do these appeals on these people. So I know that there's a lot of work being done, so I credit you all for that. Thank you.
Okay, so we do have a delegation here this evening, if council's done so far, from the BIA. And I would invite that person to come forward, introduce themselves.
Good evening. My name is Lisa Brett, and I am the chairperson of the Leamington BIA. I'd like to thank you for allowing me to speak to you this evening on behalf of the Business Improvement Association, which represents more than 200 businesses in the Uptown core. I am pleased to be able to sit here this evening and support wholeheartedly the initiative that is being proposed regarding the proactive enforcement of bylaws within the Uptown core. Ideally, this will spread throughout the entire community. As business owners, our businesses require us to regularly reflect and listen to our customers' comments and suggestions on ways in which we can improve. If we do not do this, our businesses will suffer and eventually we may be replaced. Our customers have told us time and time again that the state of the uptown is in a state that they do not enjoy visiting due to the lack of standards, the perception of it being unsafe, and more. Unfortunately, this is something that we have heard from our customers but do not have the ability to change on our own. For this reason, we have reached out our hands numerous times in partnership to work with the municipality on ways in which the state of the uptown can be improved through the proactive enforcement of the current bylaws and amendments made to them in order to address the recurring issues that plague our area. We were told that the hiring of a third bylaw officer would help to resolve this matter. Despite our best efforts as concerned citizens who listen to our consumers, many of us feel that a different approach is required and that proactive enforcement is one step in the right direction. We have encouraged our members to report bylaw infractions when they spot them, as the BIA was told that bylaws can only be enforced when there is a complaint filed through City Works. Unfortunately, there are a few issues with this approach. Firstly, many of the people who work day in and day out to operate their businesses are not familiar with all of the technicalities in all of the bylaws, nor have the time to devote to trying to spot them. Secondly, we are striving to build community spirit amongst our members, and many of them do not want to snitch on their neighbors for fear of becoming known as the screechy wheel and that their complaint will not remain anonymous. Thirdly, it is felt by many that the taxpayers should not bear the burden of being required to scope out our district and file reports. Police officers do not wait until someone reports a drunk driver on a highway, and when blatant bylaw infractions are obvious, it should not be the taxpayer that has to report this, but rather the staff hired to handle these matters. Lastly, many times we have brought forth issues as simple as broken windows that have been taped back together, which we can all agree is a safety issue, only to be told that the province does not permit the town from acting to rectify this situation. This is frustrating to say the least, and frankly, very hard to believe. Entrepreneurs are drawn to vibrant areas when deciding to take the risk of investing their hard-earned money in a new business. Our goal is to recruit and retain reputable, legitimate businesses to our district. We have attempted to do this in the past without success due to the current state of the uptown, and it is for that reason that we have been working extremely hard to advocate for and retain the current businesses who are working harder than ever to stay afloat in this current climate while getting more and more frustrated with each passing year. We have attended province-wide conferences and have utilized the resources available to us through the Ontario BIA Association. We have been told by other BIAs that our district is in crisis mode, and when we explain the circumstances happening and seek answers on how to address them. We have been told that we need our council and administration to act in order to solve this crisis. Again, we are reaching out our hands in partnership and welcome the proposed proactive bylaw enforcement within our district. We hope it proves to be successful, and we will gladly offer any assistance that we can to aid in achieving the goal.
Thank you very much. Questions from council? Okay, thank you very much.
Thank you.
Pardon? Ms. Horton?
Just wanted to mention one thing in follow-up to Ms. Brott's comment about the broken window. I do believe it may have been the position of previous administration that broken windows cannot be ordered to be repaired under a property standards bylaw. However, we do receive requests for enforcement in connection with broken windows on many occasions, and we do follow up on that and have been successful, and will continue to follow up on broken windows in the uptown, because I know that is a very visible, unattractive thing to see when you are visiting the uptown. So that's certainly something we do act upon.
Correct. Okay, so for me, just to finish get my comments in too, I guess, well, never mind. This report was on City Works, and I found the report extremely informative, and it backed up everything that council has been saying, explaining why we can't enforce things. or why it takes as long as it does to enforce things. And provincial law, whether you agree with the comment or not, supersedes municipal law every time. It's not an excuse, it's just a fact. And I know we've told BIA, we've told taxpayers, we've told Chamber of Commerce the same thing over and over again. And this, if you read this report and read it, really read it, the explanations are all there. It's all there. Why it takes so much time to do everything. And again, as has already been said, I applaud our staff for being here tonight. This is your time off. You did not need to be here to hear this report or hear the comments that were being made. And I know you work hard. And I know you put up with a lot of junk that the rest of us don't have to. This is a tough part of your job, of administration's job, and council's job, because we get hit with this everywhere we go. But when I read this report and I see the number of cases that are being handled and the efforts our staff have to go through to try and resolve these things, it frustrates me that we have to keep explaining over and over and over and over again why it takes the time it does and what rules we actually have to follow and the laws we have to follow. It's just the reality we are in. Myself, I look at this proactive thing, and the way I read the report, it's interesting to hear everybody else's translation or interpretation of the same. Way I read it, we should run away from this. It sounds to me like we're going to get ourselves into a pot that we're not going to be able to get out of. As a taxpayer, I look at it and say, well, if this is just for the uptown and you're doing a pilot project, that's not my tax bill to pay. So if council wants to support this, and I'm not totally against it, because we do have to lay down the law and enforce it to the best of our ability, then I say the businesses uptown pay for this pilot project because it's specific to their area. You alluded to it, the question was asked by Councillor Dunn, that if we take one of our 2.5 bylaw enforcement officers, really, because one's strictly for parking, and just say, here you go, you're in the uptown, that's all you have to do, proactive bylaw enforcement, we're now down to 1.5 looking after the rest of the municipality. Councillor Verbeke and I, living out in the country where we do, so we're paying and not getting looked after? This isn't going to float with the rest of the taxpayers. I know we all want to fix the uptown. I read what I read about this proactive and the amount of trouble we're going to get into, and I just enter with caution, is what I would say. If we need to beef up our bylaw enforcement, then let's discuss that during budget time. We've gone from 1 to 4 in a short period of time that I've been on council, and the workload just keeps growing and growing and growing. There are a lot of comments I've made here tonight by all members of council I agree with wholeheartedly. But I really have a hard time swallowing this proactive presentation. When it comes to the window covering issue, again, personal interpretation. What's pretty, what's not. When I was a retailer, when my dad was the retailer, when my grandpa was the retailer uptown, we would never cover our windows because we always wanted the police to be able to see in to make sure nothing untoward was happening when our business was closed. Why people do it today is beyond me, but I think of Gino's restaurant. You mentioned there are some cases where you actually need those windows covered. When Gino's was in operation, he had that sun come in and he had blinds put there, so his windows are covered. Other ones, I look at them and I think, God, that's just awful. But it's their choice. It's their business. It's their window. I don't know that we are the people to say how you should decorate what you do. But do the public consultation. I'm in favor of that and find out. I know the police don't like the windows covered. I know they don't. We've had that conversation for years and years. The enforcement, as reactive as it is, to me, it seems to be the most efficient way and the safest way for this municipality, any municipality to operate. Like I say, when I read the legal opinion on the proactive, that scares me. I just think we're setting ourselves up. But this is council's view all the way along. I know I was trying to make a couple of notes. When you brought the example of that one singular case, I'm pretty sure I know which one it is, but 125 hours and 40 photos from each department, all of that stuff that has to go in one single case. And I don't know how many months it's been running, but it's been running for a while, and there's more coming from it. That's the frustration you face, the council learns about, and that the citizens don't know about. I hope this report goes to the BIA and they have a chance to read it thoroughly. I hope it goes to the Chamber of Commerce so that they have a chance to read it thoroughly. And I wish we could publicize it on social media or in the paper so that the general public can read it and maybe gain a better understanding of why. I know it's frustrating. It's frustrating to us. It's frustrating to each one of us. It's frustrating me because I take calls and emails and face-to-face all the time on it. But this report, Ruth, was just absolutely awesome. It gave council a ton of information so that they can maybe have better discussions going forward. So I thank you for that. So there are recommendations here, council, and it's your choice to make tonight. Recommendation 1, that council direct administration to undertake public consultation related to the regulation of window coverings. Option 1, council to direct administration to maintain reactive bylaw enforcement within the uptown. Option 2 is to go to a proactive bylaw enforcement as a pilot project using a current bylaw enforcement officer specifically to this project. And in option 2 is administration bring forward a report in connection with the impact of this project prior to the 2019 budget. So it's on the floor. What are council's wishes? Councillor Wilkinson?
Quick question, sorry for the late. If we did this pilot project, what do you think the time period on that would start? Right away? A few months from now?
When would the officers start? This week.
Councillor Verbicki?
So then, instead of them going around, going door to door and telling them, I'm sure the BIA already has maybe a letter or something that they send out to their, and if they read it or not, the businesses to say that this is coming and this is what you need to do, or to retweak it again. I mean, you know, you can't keep reinventing the wheel. If it's something's done already, don't do it. But are we talking now? That was the question I was going to ask from Councillor Wilkinson. So are we talking from now to the end of the year as a pilot? Do you have a specific date, or when everybody's happy? Are you talking Monday, Wednesday, Friday? I mean, there's so much. I mean, I run out there, and when I see my car being tagged with the chalk, I get the heck out of there in 2 hours. So I mean, is there a time frame that this is going to be? I guess, like, this is new to you. You maybe surmise that this is going to happen, but I know with Kyle there and all that, does it have to be every day that they have to be uptown?
Yes.
For proactive enforcement to be effective and to not be seen to be operating negligently, then it will have to be an uptown every day, most of the day enforcement. Yes.
Be similar then to parking. He's going to make, I guess, yeah, I could say they're going to make their rounds every 2 hours. I mean, you know, the uptown's really not that big, and they can see that. To me, it's, I guess there'd be maybe other stuff out there too to do, but I just, you know, if it's going to be every day, is there a period? I mean, you're going to do a pilot project. You're not going to enforce anything until this becomes a goal of the council, this council or the next council, or are we just going to give everybody warnings, or is it the same thing? You know, it's.
No, it would be just like receiving any kind of complaint. It will be, he'll note the complaint, he'll meet with the owner, if possible, and advise the owner, generally of the business or the owner of the property, as to what needs to be done. Look for voluntary compliance. within a reasonable time. If there's no voluntary compliance within that reasonable time, that an order would be issued depending upon which bylaw we're looking at, and then the enforcement proceedings would just proceed as if we had received the request via a third party. It would just be going out to find the infraction.
Through the mayor, I have one more. So can we specify or put it in the recommendation that until this term of council is over, that's how long the pilot project is, and then let the next one, then we can have, we can come back, because I'm in favor of everything except option 2B. You can bring back a report, you know, so I mean, can we put a timeline in there too, or, I don't know, if we're going to do it?
The intention would be that the report comes to the new council for consideration in the 2019 budget. So the report would be to coincide with if the new council wishes to proceed with the proactive enforcement, any budgetary impacts would be available and included within the 2019 budget.
Okay. Councillor Jacobs?
Thank you, Worship. Out of curiosity, though, with the existing businesses that we have in the uptown core that we would be looking at that are in operation on a daily basis, how does a proactive measure work when we have numerous out-of-town absent landlords? I guess it's fine to be proactive. You go uptown and say, well, you know, that store is crap. It's been like that for the last 6 months, the last 2 years. You know, we already know it's there. Like, what measures are we going to be able to utilize, or do we have anything in our arsenal currently that we could say, hey, you got to get on board here. We got to clean this up. The absent ones are my concern. It's not so much the ones that are here in existence and open on a daily basis, because they're there, you can have verbal conversation and come to some resolutions. I guess my concern would be the absent ones. Do you have any idea how that would be handled, Ruth?
Any property standards order or land maintenance order is issued against the property owner. So it's always really going to impact the property owner, because if the municipality goes in and does the work, any costs are going to be placed on the taxes. So the owners are the ones that are really the most liable, I guess, in the case of property standards orders, and sign bylaws too, because they're the ones that are going to suffer the consequences financially if they don't respond or don't do the work. So if we can't contact an owner, we just place the order on the property, and as long as it's something that we can access, we can go in and do the work. So for example, if there's paint peeling around window frames that are painted wood, and that's an order that we issue, and the owner doesn't comply within that period of time, we can just hire a contractor to go out and do the work. The cost is placed against the property. So whether they're in town or out of town, the consequences would be the same.
Councillor Dunn?
Your Worship, through you, Your Worship, I'd like to move recommendation number 1. And option 2A.
Councillor Dunn has moved recommendation 1 for the window coverage. Yes. And option 2, but just A? Option 2. Option 2 as a whole. Okay, and seconded by the Deputy Mayor. Deputy Mayor?
I don't have anything else to add.
Oh, I thought you had a comment.
No.
Okay. Councillor Verbicki?
Through the mayor, thanks. So the timeline is to this current council till November 30th? Trial? Pilot?
No, there's no timeline on this. It's up until the budget of the next council. So, Ruth, if I could ask, actually, lately, we haven't been able to make decisions here at council because we haven't had enough information. So tonight, we're jumping in full force in proactive enforcement without any idea how much this is going to cost. I mean, is it $100? Is it $10,000? Do we have any idea at all?
Because we're utilizing current staff, There will be no cost financially. We're not hiring anybody else. We're not authorizing overtime for this pilot project.
But if you're pulling one guy or one person, pardon me, one body away from enforcing bylaws in the entire municipality, there's a cost. So you're taking the assignment of one officer, and to me, that's the cost.
That's the cost, yes. The cost will be the impact to the balance of our requests for bylaw enforcement.
So all taxpayers are then going to absorb the cost of putting a proactive bylaw officer in just the uptown core. That's where I have problems with this. Will they still have to follow provincial law?
Yes, absolutely. So the balance of my report speaking to the requirement for a warrant to enter upon land, the requirement to issue tickets, of course, is under the Provincial Offences Act. So everything that's included in my report, the cost and the timing of enforcement remains the same. In addition to the impacts of Section 450 of the Municipal Act, which I indicated at the end of my report, is the relief from liability in the operations of the enforcement when the policy decision has been made to implement the proactive enforcement. That's probably the most impactful in our opinion, providing advice to you as your legal department, providing advice to you as your director of the department that's responsible for bylaw enforcement. As I indicated, it's appealing to provide that customer service, particularly when you're wishing to revitalize the uptown. But the cost impact to it is what we as lawyers have to provide you with the advice that it is not recommended. So in that regard, I'm torn as your Director of Legal and Legislative Services, because I can see why Council wishes for proactive enforcement, and as you indicated, the Deputy Mayor looked through the internet to determine what other municipalities have proactive bylaw enforcement, and I know that other municipalities do, usually in circumstances where there's a risk to health and safety. I know that Hamilton undertook a specific project relating to rental housing, and that was similar to our concerns regarding boarding houses, and their efforts were focused at finding those boarding houses and rental housing units proactively. But you can see why they were doing those kinds of things, being concerned about the safety of the occupants. So, and also, as the Deputy Mayor said, any training that is provided in the area of property standards from that particular association would never recommend proactive enforcement of property standards bylaws, simply for the reasons that I have indicated, that you're opening yourself up to that risk of litigation of negligent enforcement, even if those allegations are without merit, you're still put in the position of having to defend yourself. And as I indicated, there are impacts to your claims history, and then subsequently your premiums when paying insurance.
Okay. Deputy Mayor?
Quite honestly, I don't think we can afford to take a chance at not doing this. I think if we keep letting our town go down the tubes, which is to me where it's going if we don't start to raise the standard, if we don't start to set a standard and hold people to it, there isn't going to be anyone that will even want to open a business in this town. If we raise the standard, and if we have some scruples and have some guts and say to people, these are our expectations, we're going to have people who will invest in this uptown, and the tax base will increase, and consequently, it'll be a better place for everyone to live. And honestly, as a taxpayer, if this is a better place to live and more people come here and shop and eat, That, to me, I'm willing to put some money into that. That's what we want. We get mad that people are going to Kingsville. We get annoyed with all that. But good God, look at Kingsville. Let's call a spade a spade. Look at it. They don't have buildings like we do. Their sidewalks look much better than ours. I drove down the east side the other day, and there were great big long weeds. Come on, we can't afford not to do this. It's gotten to that point, we cannot afford to go on the way we're going. If it had improved in the last 4 years, I'd say we're doing the right thing. It hasn't. It's gone down in the 4 years. So obviously, what we've been doing has not worked. We have to change it, and I'm willing to take a risk.
Councillor Hammond.
Your worship, thank you. You know, I'm going to try to draw some parallels between being proactive and reactive. During my term in the fire department, which was a lot of years, we used to, once a year, do the entire uptown. We visited every store, every restaurant, every hotel. A part of that was to familiarize the new members with the location of the building and where the furnace room was and other things. But I can tell you that, and since that's gone by the wayside, but during that time when we used to do that, we found more violations with respect to paint cans being stored in the furnace room and all of those types of things. Inactive smoke alarms, inactive panels that weren't being used, that weren't hooked up properly, or somebody in a store uptown, and I'm talking about uptown Leamington, went in and they did a lot of maintenance work or did some new construction, didn't rehook things back up. So maybe that isn't a very good parallel, but what I'm trying to bring to light is the fact that being proactive and going through all of these businesses and stores uptown gave us and gave them some information that, wait a minute, you can't do this, or maybe you've done a good job and this is the way it should be. And that's why you see fire departments today in Chatham and everywhere else going through the entire town, visiting every homeowner to make sure they've got smoke alarms up because they're being proactive.
And I can understand that, Councillor, I do. I mean, I would welcome a fire department or even a police officer into my house. But these guys, I don't want them coming into my business. They're bylaw guys. They're going to make me do stuff. And that's the problem we've got. That's the problem that holds everything up, is property owners don't want them coming in to spotting what's going wrong. That's why we have to go through the court system to get these warrants, right? It's not the same thing.
Your worship, yeah, but with all due respect, it is the same thing. Because when we did those inspections back in those days, and we did every building in town, we issued orders. Many, many orders were issued. Some a lot more or a lot less severe than others, but yes, we did. And did they want to see us? For the most part, people are running their businesses and their restaurants or their bars or whatever uptown, don't mind you coming in because they're confident that what they've got there is correct and working well. It's the ones that don't want you to come in that are ones that are trying to hide something.
Yeah.
So, I mean, again, maybe that isn't a very good parallel, but it's the only example I can bring up why I think we need to be proactive.
Appreciate it. So why did it go by the wayside?
I guess time. You know, it's something that grew away. We used to do every corner of town. We would break up and we had 4 squads.
Yep.
Each squad would do a different segment of town, each corner of town in a different year. The biggest part of it was to familiarization. Why we still don't do that, there isn't a legitimate reason. We still should be doing it.
I remember it from our store, right? our many different locations that we were in. But I can't help but think maybe nowadays it's the people can just easily say, no, you're not allowed in. And then you guys have to go, the fire department has to go get that warrant, just like our building department, just like our bylaw enforcement. So I get it. I'm not arguing against enforcing our bylaws. By all means, let's enforce them. I just can't support this proactive because I think we're putting ourselves into a big pail of hot water. Mr. Neufeld.
Thank you, Mr. Mayor. It may be well understood, but I think it's worth just noting that the municipality of Leamington has for decades had a reactionary bylaw enforcement program. Within that program, what we have tried to do over the last 4 years is maintain the reactive program, the declaration of a reactive program, while becoming more proactive. What I mean by that is that when our parking bylaw enforcement officer is out chalking the tires and notices something behind a store, he comes back and makes sure that that gets reported. The example that Ms. Orton gave, where if our bylaw officer is out for a particular investigation of a complaint, and we find other things that are going on, we certainly don't not react to that. We try to see what can we do to make this better. And especially in those areas where we don't have the authority, as Ms. Orton has laid out in her report, there is collaboration with the local police and health unit and, the MOE, CP now, and the other bodies of enforcement. The difference now is that council will be making a declaration that we also have a proactive program. What that brings, and Ms. Orton has laid out some of the potential difficulties with that kind of a declaration, we may find ourselves being challenged in many different ways. That's not to say that we won't embrace having a proactive program, but it is a change in program, I guess is what I'm trying to say. And so I just didn't want it misunderstood that our bylaws officers don't act in a proactive way when we become aware of something, but rather that we will now be actually declaring a proactive program. And if that's what it takes to clean up the uptown in council's view, then certainly that's what administration is going to do. I think the pilot project itself, the idea of that, was to get a sense of what the impact will be on the reactive bylaw enforcement program, because we are going to be removing some resources to that, which will also then give us a sense of how, if we need more resources, what that cost will look like. Now, on the other hand, if we are more proactive, perhaps the reactive complaints will be decreased over time. And that was the other thing that I wanted to see, is that if we have somebody in a proactive role, will we see a reduction in the number of reactive complaints? Because if we do, well, then we're getting ahead of the game. But when you see the number of complaints, and I think it was 571 all of last year and 582 to date, will give you an idea of the number of issues that our bylaws officers are reacting to on a regular basis. So I just wanted to make those comments that it's actually a change in program that council is approving here, but the proactiveness of our bylaws officers has been maintained over the last 4 years, but just not in a programmed way.
Councillor Wilkinson.
Mayor, I'd like to go back to your comment there. That's the second time in the last two meetings I've heard you make a comment about council not being prepared, and it was in regards to our uptown revitalization. As respectfully as I can say this, I'm insulted by that. I would think the rest of council is as well. You're referring to the Uptown Revitalization Project. That's a $7.5 million project. It's a 94-page report that we got on Thursday night. We need to be in here on Monday. I worked my damn ass off until about 2 in the morning that Sunday night to make sure I was prepared here for Monday night. I was prepared. It wasn't me. I don't think it was any other member of council that asked for that to get pulled. It was our CAO.
No.
Okay, fine. Any council member is not comfortable with $7.5 million along with a major project that reshapes our town. By all means, please take a little extra time. We can get this done. So I just hope going forward here, I've heard it twice now, I'd rather not hear it again, and that's my comment.
So, we have recommendations before us. What are council's wishes? We have a recommendation on the table, sorry, okay. So, ready for the vote? Sure are. Recorded vote, please.
I'll just repeat the motion before council. So on the floor, council direct administration to undertake public consultation related to the regulation of window coverings. Number 2, council provide direction to administration to commence proactive bylaw enforcement in the Uptown as a pilot project and assign a current bylaw enforcement officer specifically to this project. Administration bring forward a report in connection with the impact of this project prior to the 2019 budget. Moved by Councillor Dunn, seconded by Deputy Mayor. We'll ask all those in favor to raise your hand and please leave it raised. Councillor Dunn in favor, Councillor Hammond in favor, Deputy Mayor McDonald in favor, Councillor Jacobs in favor, Councillor Wilkinson in favor, Councillor Verbicki in favor. All those opposed, please raise your hand. The Mayor is opposed. The motion carries.
All right, move on to the next report is Business Licensing Bylaw Review Program. Ms. Percy?
At the direction of council, administration brought forward a report in 2016 with regard to the concept of a business licensing bylaw. As a result of that report, council directed that administration bring forward a bylaw respecting licensing and regulating businesses operating in the municipality of Leamington. A comprehensive bylaw was approved in November 2017 and became effective in 2018. Prior to the passing of a business licensing bylaw, common complaints included such things as businesses operating illegally, businesses operating without proper inspections or out-of-date inspections. Illegitimate businesses were not following the rules that others were required to follow, resulting in an unfair playing field. As noted in the report brought to council when the bylaw was passed, the focus of the first year of the program was to be on education and outreach activities to inform business owners and the public of the bylaw and requirements to obtain a business license. Education and outreach also includes explaining how compliance can be achieved. A number of education and outreach activities have been conducted over the past 8 months. Some include a public awareness campaign, publishing of ads in the local paper, posting information on the municipal website, attending a business coffee break hosted by Chamber of Commerce where administration reviewed the bylaw and answered questions, assisting owners by referring them to the appropriate agencies for any additional information they may need about running a business, such as how to get our HST information, registering a business number with Revenue Canada. And we also directed those interested in to the Economic Development Officer for any support that they required, or the Windsor Essex Small Business Centre. Over the past 8 months, administration has worked diligently in administering an impartial, consistent, fair, and equitable licensing program. Administration has worked very closely with businesses, providing assistance in the business license application process where needed. It's estimated that the licensing assistant has met with over 250 businesses to explain the bylaw, to assist them in completing the application when required, and has responded to well over 1,000 inquiries, whether those be in person, by phone, email, or letter. They've also met with a large number of the Spanish-speaking business owners and provided direction and assistance in Spanish. In fact, a form letter was created in Spanish to accommodate those owners who do not speak English. Administration predicted at the November 2017 council meeting that the implementation phase of this program would take 1 year. As requested at the July 9th council meeting, administration is providing a progress report. So the first item is current statistics. To date, 320 business license applications have been received. The public response. A survey was recently conducted with 25 random business licensees to gauge satisfaction with the licensing process. Overall, the response was positive. Some of the comments received included received CIP information and helped better understand building permit requirements. The cost of licensing is high considering the type of business being operated. Fees are reasonable as similar to Windsor. Process is easy, not complicated. Ensure the municipality continues with bylaw to ensure businesses are doing business in a proper way. It's just part of running a business and the fee was reasonable. There is a need to weed out illegitimate businesses. The process was simple, makes everyone accountable. They'd like to see enforcement. Too much documentation required, including corporate documentations. We're not aware of a need for a sign permit until they've applied for a license. Some concerns raised outside of the survey have been that the fee is too high, the requirement for each employee to have a food handler certificate is excessive, festivals are not required to have a business license, is the municipality ensuring that businesses collect and remit HST, do vendors operating at festivals have a food handler certification? Most often, concerns raised or criticism expressed were as a result of not having accurate information or not fully understanding what's required. This is why the education component of the program is so important. The majority of business owners were satisfied once they better understood the process and any misinformation was cleared up. Administration is confident in saying that less than 10 business owners remained unsatisfied with the program due to their not wishing to provide the documentation or their belief that the bylaw was not necessary or should not apply to them as they're one of the good businesses operating for a number of years, or they do not agree with the licensing fee being charged. Fees. As council will recall, the licensing fees were developed from a full cost recovery and analysis. Licensing fees include the cost for inspection, administration of the licensing process, overhead, and compliance costs associated with the specific license type. The annual renewal fee is lower than the initial fee, as it's expected that a business wouldn't require a planning review or a building review. When recommending the fees, administration did review a number of comparator municipalities to ensure that the fees were consistent. If the fees are reduced below the cost of administering this bylaw, the taxpayers are subsidizing business owners. Annual renewals. There have been questions about the requirement for annual renewals versus a 5-year renewal or no renewal at all. Annual renewals help the municipality track business activity by collecting data on movement, closures, ownership changes, and they allow the municipality to ensure ongoing compliance. This information can only be collected through the submission of an application and required documents and is only accurate if it's updated yearly. The processing time for an application. Once an applicant files a completed business license application, it is then circulated by the licensing assistant through a number of internal departments for review. The typical processing time, once the application has been received, a complete application has been received, until the license is issued, is approximately 31 days. Given that the program is new, departments are still working through the best practices and procedures with regard to reviewing the applications and conducting the applicable inspections. The benefits realized from the bylaw. The report includes a number of benefits which have already been realized from this program. Some include Building Services has noted that the process has allowed them to identify all businesses that have undergone new construction, renovations, plumbing, or changes of use of the property that did not apply for a building permit. Building Services has been able to clear up outstanding building permits. The business license application requires that the business owner identify how they plan to manage and dispose of their waste. Finance and Business Services has indicated that they expect to realize an increase in the municipal tax levy as a result of the implementation of the business licensing bylaw due to the identification of home occupations. Economic Development has indicated that the program has noticeably helped increase awareness of the CIP and been partially responsible for the increased number of inquiries and applications received this year. Fire Services has been able to inspect those businesses that did not have up-to-date inspections of their premises and/or recent inspections of equipment, such as fire extinguishers. With the implementation of the bylaw, the fire department has been able to ensure that those who require a fire safety plan have completed or updated the plan. To date, there has been 25 new plans submitted or in process. Planning Services advises that this process assists to identify where existing uses were improperly located and did not meet current standards. The business licensing process provides data on numbers and types of home occupations, helping the municipality understand what the demands for commercial space is. This is a benefit when designing and zoning lands. Administration has included some recommendations for improvement to the bylaw. The first, recently it was identified that a home occupation is required to have 2 off-street parking spaces and a further 2 off-street parking spaces on the business premises. This created difficulties for some home occupations to meet the requirement. It also does not take into consideration that businesses' impact on that neighborhood. An administrative report with regard to this issue and proposed temporary remedy is included on the agenda tonight for Council's consideration. When the bylaw was developed, administration consulted with the health unit with the requirement for a food handler certificate card. It was the health unit's recommendation that a card be required by each employee handling food. The health unit's legislation has recently come into effect, since the passing of the bylaw, and only requires that 1 person per shift have this card. Therefore, administration would be agreeable and recommend that the bylaw be amended to reflect the same requirements as the health unit's legislation. When developing the business licensing bylaw, the BIA representatives asked to include a requirement for all businesses to provide a copy of their master business license. The master business license is a provincial license issued under the Business Names Act. A business is required to register for a business name with the province if operating under a business under a name other than the legal name of the owner of the business. Given that the requirement for this business name registration became more of an impediment than a benefit, administration recommends removing the requirement from all businesses to provide this document. There has been feedback from bed and breakfast establishments on the requirement to provide a vulnerable sector search. It was included in the bylaw as a means of ensuring that those individuals who intend on working with the vulnerable sector, such as children and elderly, were properly screened. The check is also required from driving school instructors, ice cream cart and vehicles, and door-to-door salespersons, as these persons typically are operating such business in closer proximity to the vulnerable persons in secluded or isolated situations than those persons operating another type of business. Administration would not recommend removing this requirement for the bed and breakfast establishments. It is important to note that the removal of this requirement may expose the municipality to a liability in the event that a bed and breakfast operator takes advantage of or abuses a client. Public health and safety remains one of the rationales for business licensing bylaws. The municipality could be seen to have determined that a check had been required at the time of the bylaw's adoption for public safety, but now does not. Any person harmed would argue that this was negligent on the part of the municipality and not a simple policy decision, which is protected under the Municipal Act. In 2019, administration intends to review including a specific category for hotels, motels, and Airbnb businesses. Currently, these businesses are required only to obtain a general business license. However, given the nature of the industry, it may be appropriate that additional conditions be applied similar to those that a bed and breakfast establishment is required. Administration is otherwise satisfied with the bylaw and would not recommend any further changes at this time. Overall, the program has been in existence for just 8 months. This is not sufficient time to accurately evaluate a program. It's important to note that a number of other programs have now been based on the business licensing bylaw and application process. For example, the recently approved bylaw regulating cannabis production and distribution requires that Part 2 cannabis facilities are licensed pursuant to this bylaw. It is anticipated that the recommendations relating to the licensing of boarding houses will also correspond with the need to obtain a business license. Under financial impact, it's difficult to determine within any accuracy the number of businesses operating in the municipality, and as such, the estimated financial impact associated with passing of a business licensing bylaw cannot be provided. There has been an expected impact upon staff resources. The 2018 budget includes revenue from application fees, which includes costs for contract staff to assist with the implementation of the bylaw to ensure success of the program. Realized revenue to date is over $47,000. Administration will be requesting that the licensing assistant position be renewed in the 2019 budget deliberations. Revenue generated from the applications and renewals will partially fund this position. So the recommendation of administration is administration be directed to implement the following amendments to the licensing bylaw. A, the requirement that a copy of a valid food handler certificate card for each employee handling food be amended to require a copy of a valid food handling certificate card for at least one employee supervising the preparation, processing, packaging, service, or storage of food. And the requirement to provide a copy of the master business license from the province of Ontario be removed. And number 2, that administration be directed to review the inclusion of a specific category for hotels, motels, and Airbnb businesses.
Thanks, Brenda. I have just one quick question before I go to council. In the recommendation under A, I know we were contacted fairly quickly by one of our local restaurant owners who was not pleased with the food handling certificates, the number of staff he has, the number that it would cost him to make sure they were all covered that way. So if he's already gone through that cost, and now we're going to just say, well, actually you only need one employee to have it, how are we going to address that? Because now that's just like totally unfair.
That's a good question. These amendments may impact those who have already gone through the process and gone to the expense of meeting the regulations in the bylaw.
Is it something that could, like, if let's say these specific businesses that have already done what we've been asked to do, like myself, if these changes then affect our competitiveness against them, could they come to council and possibly discuss a refunding of, I mean, it's a terrible thing to ask. I hate giving money back, but it's a reality. So
I would not recommend that. I mean, certainly anybody can ask to be a delegation, and if council wishes to entertain that delegation, that's council's decision. However, I would not recommend against any kind of compensation, simply because, again, it's a decision of council that council made. It was a policy decision to pass that bylaw. It's a policy decision to amend the bylaw, and to entertain requests for compensation as a result of that really opens the door to a lot of different requests based upon council's bylaws and their authority to pass bylaws.
I guess I already knew that answer. I'll just have to go eat there more often. So, okay. Councillor Jacobs, I had.
Thank you, Worship. I guess after the previous lengthy discussion we had here for the last couple hours on being proactive, I think this is basically falling in line with those steps, simply because we're looking at businesses, as Councillor Hammond is suggesting, or fire department had the opportunity to inspect these places, which isn't happening anymore. This is going to provide those options for us. And I'm in agreement with them, and I'm in agreement with the amendments that you're making. However, I feel that there's still a lot of tweaking within this document that needs to be done. Excuse me. And looking at home occupations as an example, where we're looking at implementing 4 minimum parking spots for some of these residents, which is almost an impossibility for them to provide. I would think that there needs to be something along those lines that need to be corrected. And going through it, the majority of it, I feel that are good moves that we're making. But on the other hand, I feel that in some of these instances, we're really imposing a real hardship on some of these individuals. I look at the B&B section, I look at the home occupation sections and so forth. Downtown businesses that are in operation, they're providing parking through the BIA programs and so forth. And I don't know, I'm having difficulty with some of this. And I think for me to pass this without going a little bit deeper into it is a little bit premature for me. again, I like it. I think it's a move. If we're going to be proactive, this is going to be a key factor in being proactive for the rest of it. But I think we need to do some more tweaking and look at some of these areas a little more closely where we're really not going to put certain individuals right out of the market. So that's my feelings on this. Thank you.
Councillor Verbeke.
Well, we're the mayor. I mean, I heard the word policy and council did this, and we went on the recommendations of this. However, we were told by a few bed and breakfasts that if you have more than 2 rooms, you need to be inspected, and we laughed at it. I know a lady, when I hold my round table discussions daily, has paid $1,000 to have somebody come in, pay staff, for them to take the food handling course. And now we're going to say no. There's got to be some compensation or credit, I'm sorry. And if we make the policy, then we can also make that policy too. So that's where I stand, because this is ridiculous. And Councillor Jacobs, yes, we've only began to pick at this. There needs to be more also in this, that we probably found some more too. But those with the bed and breakfast, 2 beds or more, we were all told and got the letters. And my inquiries were that if you have over, they don't need to be inspected unless you have 4 bedrooms. And then this food handling course is just, it's malarkey.
Councillor Hammond.
Your worship, thank you. Well, I'm glad that you brought up the reimbursement for the necessity to have those licenses, because I too have got that written down in the form of a question about what are we going to do for these people now. I agree with Councillor Jacobs that I think that one of the things that I hear the most is the cost. And in Brenda's report, and by the way, a good report, Brenda, as always, but I hear that we're looking for a cost recovery, for the staff time, that's devoted towards these business applications. But I think the real intent, though, wasn't it not necessarily for a cost recovery, but to get the businesses to register. I mean, that was our focus, wasn't it? So we knew who was legitimately running a business and who was not. Ideally, we want to get a cost recovery. So along with the statement made by Councillor Jacobs, I too think that there's a little bit more tweaking. That's one of the areas of concern that I hear most often is the cost. The words that are used are cash grab, and I don't think they put into consideration the amount of time that's being spent. So I too think that maybe we, again, we've already talked earlier on tonight about setting things aside and getting a better look at it, but I'm wondering if that isn't, maybe a little more tweaking is necessary before we pass this.
Councillor, my recollection, you're right, it was to get legal businesses to register and get the illegal ones to come on board. But my recollection is council was very clear that based on the recommendations we had on this bylaw was to make sure that we did cover our costs. We have this argument every time in budget deliberations, right? When we're doing building inspections, Peely Island, whatever, we always want to make sure we're getting our costs covered. So I think that was part and parcel with the other part, saying, yeah,
you're right.
Please register.
Your worship, you're right. I mean, I understand that, and I was a part of those discussions as well, and I understand the importance of that. I'm only trying to bring forward the number of, not necessarily the number of complaints, but that's the one I hear the most often, is about the cost, or, there's a couple other ones, but that seems to be the most. And I know, Brenda, you already, if I can ask one more question that I didn't earlier, but you had indicated it's pretty tough to tell how many businesses out there right now there really are. But what do you guesstimate the compliance is at this point with the businesses that we know are there? What do you think the compliance rate is right now?
It's extremely difficult. We are aware of more businesses. Those are the businesses that have already applied and are going through the process. We have a number of letters that have gone out to other businesses that we're aware of, and we're not including that in the calculation, obviously. So I would probably say we're at 65-70% right now, but that's just a very wild guess.
Councillor Wilkinson.
Thank you, Mayor. Much like CityWorks, I think we have, I supported it. I voted in favor of the business license bylaw. I think we do have something here. and I don't want to throw the baby out with the baby water, is kind of the way I feel about this. But after 8 months of, 8 months is a decent, window to see what's happening. I think we really need to hear from our stakeholders. I have a number of concerns myself. First of all, the extra cost that's heaped over and above just going through the process of the business license. It's not your $250 or $300 or your annual renewals. It's the extras after the fact. Maybe some are hiring lawyers. Maybe some are whatever. They have to pay for courses, whatever. Shame on me for not thinking about those. I didn't think about that. I made a mistake. Anyway, I think that all has to be considered. I'd like to have a discussion with the stakeholders about the annual renewals, the master business license being removed, the vulnerable sector check. I'm still arguing with myself back and forth on that one. Paid for public versus business operators. I look at the comments here on page 54. The basic guiding principles of business licensing by a municipality are to ensure the health and well-being of residents, support quality of life, and to protect consumers and business operators. But then we expect the business owners to fully, swallow the entire thing. I think that there is some benefit happening to the consumers as well. So I'd be willing to look at that discussion, of business and private sector paying for it. I'd have that discussion. When we started this, the term was used, this is a living document for us, and I've had to defend this numerous times. People calling my house angry about this thing. I still tell them I voted in favor of it, and I support it. I think we do have something here. But this was a living document, is what it was told. And Brenda, I like the changes you've done here tonight. I do. I support both of them. But I think it is time to have a good discussion with those stakeholders. We got to get them into a forum of some sort. Say, what don't we know about? What else is out there that we're maybe not aware of? I'd love to see the data that comes out of that. I would hope everybody would get involved in that. I don't know if it will happen. I think there's enough people that are passionate about this. According to the amount of calls that I got, we'd have a decent attendance, I would hope. That's my thoughts for now.
Mr. Neufeld.
Thank you, Mr. Mayor. Just very quickly, as I'm listening to council discuss this, I don't hear council saying that they don't like the recommendation, but that maybe there should be more tweaking. So I would hope that if council, what I would suggest is that if council is in favor at least these two, let's not hold off on at least accepting the recommendation as it's written, and then ask, let's get into those discussions. Yeah, 8 months where we've learned a lot. I mean, that's the impetus for this report, is that we've learned a few things and we need to learn more. But that's just my quick comment, that if at least council is comfortable with what's recommended, let's not move forward with at least these, just because there are other things we need to do yet.
Councillor Dunn.
Through you, Your Worship. I agree with Councillor Wilkinson's regards with, I've had a lot of comments regarding the fees, so I would like to see revisiting that. And the additional cost, I was just curious, Brenda, with one thing, that when this comes, the business licensing, is all the departments notified at the same time to try to speed up the process? I know it goes through, and I'm not sure of the whole process, but would it help to speed it up if all departments knew about each business as it comes in?
When we receive the application, we meet with every person to make sure that it's a complete application, that they have all the documents required. We assist them in any way we can. Angela spent a lot of time showing people how to obtain certain documents that are required. Once we get the completed application, it's first forwarded to planning, because if the business isn't in compliance with the zoning bylaw, then there's really no point in moving beyond that. Once planning signs off on the approval process, then it is sent out right at the same time to the bylaw enforcement department. If it's a home occupation, it would be something that they're required to inspect, and also to fire and the building department. So that's sent out to those departments right away, but planning is the first department.
Yep. So when I submitted mine, Angela helped me through the paperwork, but it was really simple. I mean, it really is not difficult to do. Bylaw came out to the house, inspected the size of the room that I use in my house. Yeah, shut me down, yeah. And then it was a struggle to get fire because of my activities and their activities, but they eventually got out to our place to inspect it too. But yes, everything was done like just binkety-binkety-boo. So it's really, the reason it took me longer than it should have was my own fault. So yeah, it's really quite well organized, I think. So I have Councillor Jacobs and Verbeke and then Deputy Mayor.
Well, thank you, Worship. If I could address Peter for a moment. Your comments, we accept this, excuse me, the changes. I think we're all in agreement of that. But carrying forward with applications, they're still bound by what we have here, are we not? Like, if we're looking at 2 parking spots, 10 parking spots, health certificates and so forth, how would that be handled moving forward when we're all in agreement that this needs to be tweaked, or, you know, we have some recommendations that we would like to see modified within this. Like, how does that move forward from there, I guess, what I'm asking.
Ruth or Brenda or Peter? Fire away.
Well, I can speak to the issue that Councillor Jacobs mentioned, which was the parking spaces for the home occupation. The next report should address that, and so I can go through what the recommendation is to address the very issue that he raised, which was the requirement to have 4 parking spaces in a home occupation. Hopefully the policy will address that issue.
Okay.
And the other issues about, like, the B&B as an example and so forth with certificates. And I guess that's where I'm going with this one. Like, I don't want to see them getting delayed getting business licenses, but I think that if we're looking at modifications to the document as it stands now, and someone comes in tomorrow to apply for a license, then you're going to say, well, you have to have this. And we're going to say, well, maybe we're going to modify that. I'm not trying to create some confusion, but...
Yeah. Mr. Neufeld.
The bylaw would be applied as written and amended. If council goes ahead with the amendments tonight, those amendments will immediately be applied. The remainder of the bylaw will continue to be applied until such time as other changes are made. If you're asking me when can we get at those things, I don't know that. I need to discuss that with my senior management team and my managers, but knowing how council feels about this, I can't make any promises, but certainly we'll be back quickly. We'll figure out a way to, as Councillor Wilkinson said, you know, maybe it's a meeting with the stakeholders. Maybe it's as simple to begin with as asking council to provide their particular the concerns that have been brought to them with the current bylaw. And then we, administration, can discuss those things without it holding things up. We can take a look at those issues and get back to council. But as per timing, it's like anything else. This is something coming back to us now on a Monday evening that we really hadn't considered. And so given the impact of some of the other things that we have to do yet, and, you know, I hesitate to say it, but it's like the sign bylaw. You know, there are so many bylaws, so many things that need to be done, but we know that this is one of the things that we may want to take a look at. It's also complicated a little bit by the pending election. Council will not be looking at changing policies just prior to the election. However, I think that at least getting the information that you have, the concerns that you've heard into administration would be the first step.
I appreciate your comments, and as I said before, I just didn't want someone to somewhat be hesitant on applying for a license simply because, well, you know, I need 5 parking spots. I know I can't get them, so I'm not going to do that, and that's something that we all agree on. But I believe it's a good document. Like I said before, I think it ties into the previous 2-hour discussion that we had to move forward, but I appreciate that. And I don't think it's a case where we're looking at upcoming elections. I think this is something that the current council has been looking at for quite a period of time, so thank you.
Councillor Verbicki.
So, worthy mayor, if we pass this tonight, and some businesses have been reluctant to even apply for this, but now I have 20 employees who handle food, I still only need one license now? I got to go back to what you said, sir. It's not right. If people have spent $1,000 to take this course, and now they don't need to, because one person still had it, there's got to be a credit, there's got to be something, because it doesn't make sense, and, well, that's all I'm going to say.
Okay. So not a question then?
I was already told that the policy we have will not, or it's not recommended to, but that's administration's policy. But if we make the decision, then there's got to be something there too, because I would like to know, the list here says 40, and I'm sure when they do the licensing, I'm going to throw it out to Angela. If you do the licensing there, do you know how many employees they have on the application? Okay, thanks. That's it, I'm done.
Okay, thank you. And Deputy Mayor.
Thank you, Mr. Mayor. Again, I think the idea of a business license is where we need to be. It was asked for, and we thought it was a good idea. And then this is where I always find counsel. We're always between the theory that comes from administration and the practicality of how it works on the ground. And that's where we are caught right now. Most of it sounds like a good idea until you start implementing it, and then you find that things start biting you in the rear end. And to me, the food handlers one is one of them, and now we're stuck with the predicament, what do we do about the money? And I'm afraid that we're still going to have a few more issues going forward like that, where we're still enforcing some of these things, and we may change our minds down the road, and we'll be in that murk even deeper. In my 8 weeks of talking to people, I've already had 10 people that have searched me out to complain about the business bylaw. I did not invite them, they came to see me. And they were in all different kinds of business sectors, and they informed me of a number of things. First and foremost, the B&B and the home occupation, even though you'd think the B&B would be a home occupation, they're not the same price. The initial fee, as Councillor McDonald, that's me, no, Councillor Wilkinson, sorry, said there's way more. We found out with what you said about the food handlers, that one restaurant paid $1,000 to have their staff between time off, taking the course, writing the exam. That was her investment. I have a gal that has a restaurant north of town. She has 3 employees. All she sells is coffee, toast, hot dogs, and she had to pay for that for her employees. It took a fair number of coffee to pay for that. I have another gentleman who called me, had to hire his lawyer because of the corporate requirements. The eating establishments, the health department rates them differently. The ones with fryers in the big establishments are checked more frequently than the ones that only do coffee and toast and hot dogs. Why can we not rate them differently as well, much like it's being proposed that we do for the parking? Second business, if you have a second business in your house, you're paying a double whammy. I got called today about a guy who has a barber shop in his house, and he had to pay two fees. And then I was kind of curious about the comparator municipalities. Are they in the County of Essex? What we wanted with this was an opportunity to find where we were in the grand scheme of things, how many businesses we had, what kind of businesses we had. We wanted to bring the underground ones into the light. I'm afraid what we've done is we've alienated a whole bunch of our businesses that have been here a long time, and that was never the intent. I know this is supposed to be self-funding, but we never talked about a revenue stream. I feel like I entered into this quite blindly, and I'm going to own it. Regardless what the mayor said about us not being prepared, I read my stuff. I read it 3 times. I went over this business licensing bylaw. I sat in the audience when we had the public meetings, but I didn't think of these questions that would come up. And that's what bothers me now. I feel like I haven't done my due diligence. I didn't ask the right questions. And now here I am, again, a bit embarrassed because I don't like what we're doing here. I don't think our intent was this. To my way of thinking, we should put this business bylaw on hold until the new council comes in. I think then we need to have meetings with the stakeholders, exactly the same as we did with the boarding house. We can invite the exact ones. I'm talking, invite Wendy from Sunflower Cafe, see how it's affecting her. Invite Ben from the barber shop. Invite Wayne Warm from the jewelry store. Invite the people that are being affected. Invite the bed and breakfast people. They will be able to give all of us an exact idea of what that impact is. We've not done that. We're between here's theory and here's practicality, but we are the decision makers, and it is up to us. It is up to us to make the decision how far this goes. And I don't think we fully appreciate the fact that it rests with us, the people at this table. I love the practicality, or the theory. I couldn't be without it because I'm not the professional, but I am the decision maker. And I am most impacted by the people that put me in this seat. I am determined to decide between the two what's best for these. And this, as it stands right now, for me, is not the best for these people. So I would suggest to you, my colleagues, that we put this business license on hold. I don't care if it's for 6 months, that you can decide that to me in discussion, but I believe that we still have some impactful changes that are going to involve dollar amounts that we're going to have to backtrack on. And yes, I think we are going to have our feet held to the fire on the amount of money that has already been spent. So I would welcome comments on it, because I just feel that I wholeheartedly, although I support the recommendation, I just feel like we are still between a rock and a hard place, and until we get all of these figured out, this is not the best business bylaw for the community.
Councillor Verbicki.
Here we go. Agree to disagree. I agree with this, but now we are going to be laughed at if people have not filed their business license and you want to put this on hold now. We're doing, a double take decision. So I agree. Let's, like Councillor Wilkinson said, it's a living document. We're going to have to, we could maybe tweak it 4 times a year, but as it sits now, we have to continue with the bylaw licensing, because we're going to really look stupid if people that, and you know a couple of them that said they've hired their lawyer and they said that one amendment there, it's going to cost them money. So people have not, they're in violation right now. And if we throw this by the wayside or defer it, they're just going to laugh. So I think that's going to be an issue that we're going to have to face also with the people that we forced into paying for this license. So, you got to look at it both ways too. I'm just agreeing to disagree with you.
Councillor Jacobs.
Thank you, Worship. I agree that we don't want to impose any more financial hardships where it's not necessary. However, with the elimination of the 2 that you're recommending this evening in this document, is there other portions within the application process that would be of a financial impact, or were those the major portions, like the licensing or like food handling licenses and the different things that they needed? Is there more in here that would impact financially to some individuals?
The recommendations that are before council, A and B, would both be a cost, I suppose, to the business owner because they would be required to ensure that they had the food handler certificate, and the master business license would also have been a cost. But other than those two, I'm not recommending anything else that would have a financial impact.
Okay, so if we carry on, there's nothing here that would be flagrantly coming out saying, well, it's going to cost you $500 for a lawyer or $100 to get a license to, I don't know, do whatever? That you're aware of at this stage?
Not that I'm aware of, no. I mean, the other recommendation within the report that administration does not recommend council to proceed with would be removing the requirement for the vulnerable sector check for the bed and breakfast. That's a cost to those owners to get it as well. But we're not recommending removing that.
Councillor Wilkinson.
Thank you, Worship. In regards to Deputy Mayor McDonald's comments and Larry's. First of all, Larry, I'm not worried about looking stupid. Nobody's ever accused me of being the smartest guy in the room, so that don't scare me one bit. It's important, though, that I do policies that impact people's livelihood, their well-being, all that kind of stuff. I take that very serious. And if I gotta go back and say, I made a mistake, I made plenty of mistakes, I'm gonna make more mistakes, so be it. I'll take that. I think when I weigh the pros and cons of looking stupid, and having to go back on what I did, as long as in the end I get to where, because I said that I think we do have something here that is valuable. It's going to be pretty, I think, down the road, maybe about 3-4 years, we're going to look back and we're going to say, we got that thing right, along with other projects that we're going ahead with in the Uptown. I don't see the harm in, I think it's the top, my priority list is getting the feedback from the stakeholders. That is the number one top priority with me, is hearing how they're being affected and what am I not hearing about as well, because I know there'll be a lot there. So that kind of answers your comment. That answers your comment. I don't see the hardship in us putting it on hold for maybe whatever time it takes to get that stakeholders meeting done and have it come back to us. I still support these recommendations here tonight. I think they're fantastic. I think this shows that we are listening and we are got some give and take. But I don't think it would kill us if we were to put it on hold and hear from our stakeholders, come back and get this thing right. That's my opinion.
Councillor Jacobs.
Thank you, Worship. Could we make an addition to this, because evidently it's pretty obvious this is going to be under review and that we're going to be looking at it for a period of time, that we can hold on the vulnerable checks for the B&Bs? Could we add that to the list for this evening? And if it needs to be implemented, then it could be down the road, or if it's going to be eliminated at that point in time. Could we add that to this and then we could keep this thing moving forward? Because that's the only other area that would be of financial impact.
So just to clarify, you're saying if the motion is not put on the floor to hold the bylaw until further review and it proceeds, the bylaw is still in effect with these amendments, you're asking for the vulnerable sector check that we require of the bed and breakfast to be included as something that is no longer required, or an amendment to the bylaw, so it'd be Form 1C? Is that what you're saying?
Yeah, I'd like to see this thing keep moving forward. I have to agree with Councillor Verbeke. I think it's something that we've implemented. We're moving forward with it, but I think that's one area that is going to be under some discussion as well. And if we could add that for a temporary hold on that, then we could move this thing forward if that's one of the issues that's going to be of a cost involved.
Councillor Dunn, and then Verbeke. Sorry.
Through you, Your Worship. I suggest we pass this bylaw as it stands, the improvements or the adjustments to it, but I agree, let's get it back to the stakeholders, ask administration to we get all of the stakeholders back to the table, find out what any additional questions or improvements we need to do, and go with it then. But this way, we can just get this, it improves it right now, and it keeps it going. How's it fair is it to cut it off and then reinstate it again? You said it was a living document, keep it moving. We just got to keep tweaking it. That's my
Councillor
thoughts.
Verbeke.
So are we voting on now to put it on the shelf? Are we voting on the people that have businesses that have refused to pay because they don't want to, don't have to pay now? Are we going to, we're not going to, I don't know, I agree with the recommendations and then continue on, but you just cannot stop it now. So I mean, let's.
We're not voting on anything yet because no motions have hit the floor. So,
No, I'm just, okay,
Yeah.
well then,
Yeah. So I agree with you, Councillor, and Councillor Dunn as well, that I think we need to keep this alive. You know what, I wasn't here when this bylaw was being considered and passed. It was a while back. I think I was on vacation, maybe, a rarity. But so I went back in the, on the CTV, and I listened to what council was saying at the time. And some of the words that were spoken was, we asked for it, we need it. The concerns that we need more officers, bylaw officers, and asking the bylaw officers to use common sense approach when enforcing. The stronger statements were, though, we're setting a bar. Everyone has to rise to it. Setting stringent guidelines. We have to be strong on these. Not bow to people who don't want these enforced. If we're going to cave every time we get a phone call, we might as well not waste our staff's time on this. I feel very strongly about this. I think we're going to get the phone calls once we implement. We have to stay strong. We have to understand only previous administration hesitated because when the rubber hit the road, council backtracked. So if we're going to set the rules and guidelines, we have to stay strong. Make sure we give administration the teeth to make sure this happens. There's no sense setting a bar if we say, nah, not for you, but for you, well, maybe for you and not for you. We can't do that. We're excited about this. We're not concerned, but concerned council will back, not convinced, council will back it 100% of the time in 100% of the instances. I love it. We have to be strong, moving forward. It's exciting. And I think that's everybody's opinion up here. And it is a living document. Councillor Wilkinson, you are correct. And we said that from the get-go. And that's why I think we have to keep this rolling. And we do have to stay strong. And maybe there are some mistakes in there that we've made. And we're going to have to correct them. These are the first few that are coming to our attention that should be changed. And I think they're great recommendations myself. And I think Mr. Neufeld is correct, that if council were to list what they think needs to be addressed, based on what we've been hearing, and we've all been hearing a lot of comments about this. And you're right, again, Councillor Wilkinson, maybe having the stakeholders come in and express their opinions is a good idea too. But to shelve this, I think would be really, really not a good idea. Just, again, just my opinion. I think we have to keep it moving forward. It was the business community who really pushed and pushed and pushed to make this happen. And so now we're dealing with the business community and the results of this bylaw. So if the motion is made, I'm going to follow the recommendations, and we can go from there. We'll have Councillor Hammond and Jacobs.
Your Worship, thank you. And I think we're all on the same page here. We all want to see it tweaked or improved to better the merchants and the people and the business owners that have to comply with this. I agree that it's a living document, and my concern is this, and hearing through some of the conversations, that if this is shelved, in other words, if we put a stop to this for this period of time, with the intent that we should wait for a new council to come in, and if that new council takes a while to get up to speed, we could be into renewals for these people, who are going to say, now they've already registered, and they've already done all the necessary paperwork that needs to be done, now they're going to say, well, whoops, this is on hold now, so I'm not even going to go bother renewing, which means then they've got to come back and as a workload to staff and go through this entire process all again. So I think that the comments and the suggestions that have been made here have been good. I think that we need to move forward on this, take the recommendations made by Brenda and her committee, and pass those, and get some more input so that we're not backtracking on this, and so that we are looking forward to see what the changes that the merchants are telling us that really need to be made.
Councillor Jacobs?
Thank you, Worship. I would like to make the motion that we accept the recommendation, but I would like to add to that, if I may, the addition that we hold on that vulnerable sector check, because it is a cost. And as we're reviewing this, I can't see where it would be that further down in the future that we would be reviewing that. So I would make the recommendation with that addition, if that's acceptable.
It is.
If I get a seconder?
Yes.
Just to clarify, the vulnerable sector check is also required for some other businesses, as noted in the report. Are you speaking just the requirement for bed and breakfast owners to provide it?
Which other ones, if I may ask? I slipped by me here. I got notes all over the place. But.
At the top of my head. The ice cream trucks, sorry, just give me 2 seconds to find that. Okay, driving school instructors, ice cream cart and vehicles, and door-to-door salespersons.
Oh, okay. Well, with the exception of the door-to-door salesperson, I really don't see a real issue with the other ones. But yeah, I would say for anybody that's involved in that, because I can't see that going that far down the future before a decision comes back to us.
So to just be really clear, John, what are you're saying move all these recommendations, but add the removal of?
The vulnerable sector check at this time, because it's a cost for the recommendations that you brought forward.
Just the B&B or everybody?
Well, it's going to cost, and I think that's where the fear is. We're saying that we're having cost involved with individuals that are applying, and we're worried that it's going to be possibly rescinded or whatever. So if it's going to be a cost involved with it, I would say let's get rid of those temporarily, and then they can be implemented. Okay. Or is that going to be too confusing to put in, or would it not? Ruth?
Well, first of all, I have a motion on the floor, so I do need a seconder. Or
I want to clarify the motion, Your Worship, if I may.
But I got a feeling. Yeah, you really do need a seconder. So, okay. So now, Ms. Orton.
So Brenda touched on it in her report about the removal of the requirement for a vulnerable sector check. The reason that those requirements are put into the bylaw is certainly not to place a burden upon the business owner, but it's for the protection of the public. So the consideration when we look at those businesses and when we look at other best practices in other municipalities is what positions or what occupations would be in close proximity to vulnerable people, meaning young children, the elderly, people traveling alone in the case of bed and breakfast, or in a remote location, and have the opportunity to prey upon these people if it's a person that has that propensity. So the reason for the vulnerable sector check is to ensure that people who have records, specifically records of sexual offenses, are not issued business licenses by the municipality to operate a business that they have and are in proximity to vulnerable people. So I just want to caution council, and it's certainly your decision to make, to not just consider the economic impact to the business, and I believe the cost is $35, and Brenda, correct me if I'm wrong, if you're aware of the cost, I believe $25. And it's, you can receive that from our local OPP detachment. So the cost is not significant in my opinion. And I just want to advise council as to the reason for that provision being in our bylaw. So just to take that into consideration.
Okay, I thank you for that. I thought it was going to be a costly venture where they had to go through a bunch of documentation. So basically, it's like a police clearance check, is what you're saying. All right. Then I will move that forward as recommended, then I guess that's, if that's...
Okay. So the motion on the floor, we still have more discussion. Motion on the floor is the recommendation that's included in the report. Moved by Councillor Jacobs, supported by Councillor Berbiki. So, Deputy Mayor.
Okay, a couple things. I want to tell Angela that there has not been a single negative comment from people that dealt with you. I think you need to know that. Even though we're discussing the pros and cons, the people have commented on how much you helped them, and I meant to say that at the beginning. Appreciate it. I was only talking about putting it on hold while we looked at other costing things. I think we need to look at the renewal fee at some point in time, but that's why I put it out. I wanted it out here. I wanted to hear your opinions, and I'm fine with it. If my colleagues think that, I can go along with it, as well as what the recommendation says. But I do want to say something in rebuttal to Councillor Hammond. If this is a living document, as you've said, and I think we said it from the very beginning, that new council that comes in will better get their behinds in gear, because they're going to be dealing with this way more than we probably are thinking. I think this is going to take a while to get this where it is palatable to everyone, including council. And like I said, particularly the renewal fees, I want to have a big discussion on that. And I still think we need to have that stakeholder consultation, because we need to hear how it's affecting those people. We didn't hear that. And yes, the mayor's right. We all thought it was a really good idea. But like I said, when we're caught between theory, and this happens so many times here, where the theory sounds good until we find out how it affects people. It's good on paper, but on pavement, it's a different story. So I will go along with the recommendation. I'm happy that we're taking care of the food handlers. I think that needed to be taken care of. It's too bad the people that have spent the money, that's a mistake. And I'm hoping we can find some more ways to make it not to be a burden. And I don't want people to look at this and go, okay, so I'm thinking about opening a coffee shop in Leamington or Kingsville, and then they go, wow, Kingsville's a lot less complicated. I'm going to open there. I don't want that to be that. I don't think any of us did. This was all to make things better. Our intent was good. I'm just not, I don't think we have the ideal solution. Anyway, that's good. I'll support you based on what you said, and I really wanted to put it out there to hear what your thoughts were.
Ms. Horton?
I just want to point out, in addition to all the work of writing the report, Brenda went to a lot of, she went to the measure of actually seeking some stakeholder input into it, and actually issued a survey to a random number of businesses. So the comments that are in this report are based on that stakeholder consultation. There was 25 responses received, and the comments are summarized in the report. So I'm just a little bit curious as to what council is seeking based on the stakeholder consultation, and how council sees us obtaining those comments. I can tell you a lot of the comments that we have received and have taken into consideration also have flowed through Angela. They've been comments and that we've heard from the council members over the last 8 months, the questions that have been received, the questions that Angela received, the questions that have been sent in via correspondence or email through the clerk's email. So we felt like we had a lot of that consultation that has been really obtained and taken into consideration over the last 8 months, in addition to the 2 information sessions that were held before the passing of the bylaw. So I'm just curious as to what council and how council sees us receiving the feedback in order to provide more of that in our next report.
I had Councillor Wilkinson up next.
Thank you, Worship. Ruth, I'm glad you asked that question. I wanted to, if it was a perfect world for me, I'd like to see a special meeting of council. I think just discussing the finer points that I'm struggling with here, the 1, 2, 3, 4, 5, we could have a fantastic special meeting of council here. And if we get all the stakeholders here, we have a forum. This could be quite a, it's an important piece of it's an important bylaw. There's a lot of discussion that can be had, and I don't think it would do it justice to try and talk about them all tonight. I think that would be good to have at a forum like that. That's, in my mind, what I was hoping would happen. Going back to the motion, I would insist that something be in there to improve upon that motion about whether it be a forum, whether it be a special meeting of council, whatever council agrees on. I'd like to see that added into the motion. But as to your comment, Ruth, yeah, I'd like to see a special meeting of council hold. I would take half a day off work to attend. That's just my thoughts.
Deputy Mayor.
I guess I looked at it similar to the boarding house bylaw where we had specific people invited to the table. I think when we hold a meeting, a special meeting of council, we get the same people that are sitting back there that would come. I think inviting certain people, even if you got 1 or 2 bed and breakfast, if you got a caterer, if you got one from almost every one of the categories represented, that's what I was looking at. These people have reached out to me in my 8 weeks. I have 10 people. That's 1 person a week. I think those are pretty good. Those are pretty good numbers. I didn't ask them to come and complain to me. They had complaints that they wanted to be heard. So to me, I believe we have to give some credence to that. And I agree, Brenda's done an amazing job. And I think that's why we were satisfied with those open house things. But there weren't a lot of people here. I think there were more members of council here than the people that it affected. I just think now that it's being applied, it hits home. And that's why you've got the complaints. So I'm suggesting having a group that's represented best in the categories here. That's what I would do if members of council want to attend. It would be to hear what they say, but primarily to me, it's the team working on it.
So, to our CAO, do we have enough direction given to you to come up with an idea?
Certainly, I understand council's concerns, that there are concerns and there needs to be further tweaking. I sense maybe a little difference in opinion amongst different council members about how we'll obtain the information from the stakeholders, whether it's a large forum, which can sometimes become unruly, and we don't end up accomplishing a whole lot. We did try the stakeholder meetings earlier, and it's unfortunate that some of these issues weren't brought to our attention at the time we asked the stakeholders. Especially the one that we dealt with tonight. That should have been easily spotted by a restaurateur to say, "Hey, do you guys know what you're asking of us?" It wasn't, and we went forward with it. So I guess what I'm saying is I'm not 100% clear as to council's direction as to how we will have these stakeholder meetings. Deputy Mayor suggested we identify some as we did in the boarding house issue, but that always has the risk of not identifying the right ones. So I would ask for some clarity on what exactly you're looking for from administration.
Okay, well, if I could, I don't think we need to include it in the motion, like, for this one, if we could. The motion's on the floor. I think we're all kind of leaning the same direction on these. So if we can just take a motion on that, and then we'll come back and talk about a solution. So, motion on the floor, in the recommendation in the report. Are there any further comments, questions? All in favor of the recommendation then? So that's carried. So, back to council then. Recommendation or direction, I'm not sure. Ruth?
I think perhaps to get the most, to reach the most businesses, that perhaps if we engage both the chamber and the BIA to perhaps assist with communicating to their membership and have a meeting in conjunction with those two organizations, that perhaps we can reach the most, and through outreach from individual council members to advise the people that have been contacting them directly that there is the opportunity in an open house setting to bring forward their comments, and we can have administration present and take all that feedback at 1 or 2 sessions and then bring that back to council. That might be the way to reach everybody who wants to have that opportunity. And then also, I'm happy to provide the opportunity to anybody that would like to contact us directly. I'm going to suggest that Brenda is going to be spending all of her time now devoted to the election, so that she will no longer be able to participate in this process. But I will take on that role so that she can devote her time to the election, because obviously that's extremely important now that we're getting closer and closer every day. So if I can offer that as a manner in which we can move forward, then that's what I would suggest.
All right, and are you okay with just direction from council, or do you need a formal motion?
Direction is fine.
Mr. Neufeld?
And further to that, if we get some advanced idea about some of the concerns, I would think that we'd also be able to identify where some of the cost implications might come from and get an idea of what those cost implications might be, so that we're at least educated on what we might hear from some of the people who have had some costs associated with implementing this bylaw.
Okay. Councillor?
We're the mayor, but everybody says that nobody works together. That was an excellent idea, that the chamber and the BIA be part of this, and maybe they should spearhead it.
Okay. All right, so direction given. We're quickly approaching the hour of termination of our council meeting, so I think I better ask for permission from council to run past our usual time. Moved by Councillor Jacobs. All right, sheepers, there I did it again. Councillor Hammond, seconded by Councillor Dunn. And I was doing so good for so long. Yeah. It has to be 100%? Okay. So, all in favor of the motion to extend our meeting past the hour of 10? Please raise your hands. Opposed? You're opposed? All right. So, let's go through what we can get done before 10 o'clock then. The next report up is the business licensing bylaw, home occupation parking requirement. And I assume Ruth? Sure. Okay.
We just get some, I don't get some clarification on what was just voted on.
Given that we have 15 minutes remaining, it's important for one of the other reports to get heard this evening.
Okay.
So I'm just suggesting that we change the agenda so that that report can get heard.
Okay, and which one was that? I'm sorry. The flyers? Okay.
That's correct, Mr. Mayor.
Okay, so then we'll go to 10.9, report regarding Leamington Flyers, and Paul.
Thank you, Mr. Mayor. Since 2007, the municipality of Leamington and the Leamington Flyers have been in agreement with regards to advertising opportunities for the Flyers organization at the Leamington Kinsman Recreation Complex in the Highbury Arena. The previous agreement was initiated on September 1st, 2015, and automatically renews annually. The amount supplied to the Flyers ice rental account helps reduce the cost of operating the team and improves sustainability of the Flyers operation in Leamington. Recently, the Leamington Flyers were sold. A new ownership group met with administration to present a new proposal. The proposal discussed the potential of the Flyers to take over the sale of and expand on wall sign advertising, home visitor bench, home visitor penalty box, and additional on-ice locations. The municipality would then invoice the Flyers directly for all advertising spots identified in this agreement at 15% of the cost of the sign location. The remaining 85% would be retained by the Leamington Flyers. The agreement would be limited to 31 Highbury wall signs, 6 on-ice locations, 2 bench locations, and 2 penalty box locations as identified by administration. In addition, the Leamington Flyers organization would be invoiced for all of these spaces upfront at 15% of the fees as established in the fee schedule approved by council each year. The Leamington Flyers would also be responsible for all costs associated with their advertising opportunities, including purchasing the sign materials and installation if applicable. The agreement requires that all existing advertisers would remain the municipalities and that the Leamington Flyers would not be permitted to transfer any of the existing advertisers to their advertising opportunities. The financial impact: the fundamental intent of the original agreement between the municipality of Leamington and the Leamington Flyers will be maintained. The municipality will see an increase in revenue as advertising opportunities will be facilitated by the new Flyers ownership group to improve the sustainability of the Flyers operations in Leamington. As part of the proposed agreement, the total advertising revenues at 100% would be $31,450 as summarized below. So therefore, if you look at the table at the end, current agreement with the Flyer, or past agreement with the Flyer last year, the revenues that the municipality received were $2,300 from sales of advertising. And under this proposal, the municipality would be guaranteed $4,717 in guaranteed revenue. The opportunities, I guess, it's important to note that they identified a lot more opportunities in wall signs that weren't there before, so it's a much larger number that we're dealing with this year. So, in discussing it with the Flyers, there were 2 options, which was to continue with the 25%, and the Flyers may not sell all of those opportunities. There's a lot of them that are there, or defer to the 15% of guaranteed revenue, which is what we are recommending. So the recommendation of administration is that council amend bylaw 13-18 to provide for a tariff of fees to be charged in 2018 by the municipality of Leamington to include bench and wall ads at $750 and a penalty box sign ad $350, and council authorize the mayor and clerk to enter into an advertising agreement with the Leamington Flyers, which will automatically be renewed annually unless either party provides 60 days notice that the party does not wish to renew this agreement, pursuant to all the same terms and conditions as outlined for the purpose of advertising at the Leamington Kinsman Recreation Complex.
Thanks very much. Councillor Hammond?
Your worship, thank you. I move the acceptance of the report.
Okay. And Councillor Dunn supports. Discussion on the motion. All in favor? Motion carries. I'm going to try and squeeze one more in here, 1010, the Election Compliance Audit Committee. Ms. Percy?
The Municipal Elections Act requires a municipality establish a compliance audit committee by October 1st, 2018. Under the act, a qualified elector who believes on reasonable grounds that a candidate or registered third party has contravened a provision of the act relating to campaign finances can apply for a compliance audit of the candidate or the third party's finances. Applications for the compliance audit are submitted to the clerk, who forwards to the compliance audit committee. In 2014, Council approved terms of references establishing the committee for that current term of Council. In accordance with the terms of reference, the mandate of this committee is considered complete at the end of each four-year term. It's therefore necessary for Council to appoint a committee for the period of December 1st, 2018 to November 14th, 2022. The Act specifies that compliance committees are composed of a number of members between 3 and 7, ideally to include auditors, accountants, and lawyers. The terms of reference attached to the report recommend that the committee be composed of 4 members, one of which is to be designated as an alternate. Again, this is consistent with the last committee that was established. The clerk will establish administrative practices and procedures for the committee in accordance with the Municipal Elections Act and carry out any other duties required under the Act to implement the decisions of the committee. There's no consistency among municipalities in establishing the remuneration for the members. The range is typically between $45 and $200. Administration is recommending that the compensation for the members be set at $135 per meeting, which is consistent with the compensation that was paid to the last committee. Upon approval of the terms of reference, a recruitment of the committee members will commence. The financial impact, the Municipal Act states that a municipality is responsible for all costs in relation to the committee's operation. If costs are incurred by the committee, the costs will be charged to the Municipal Elections Act. So the recommendations before Council is that a compliance audit committee be established, the terms of reference attached be approved, the clerk be delegated the authority to amend the terms of reference for the Compliance Audit Committee due to legislative changes, or in the opinion of the clerk, the amendments do not change the intent of the terms. The clerk is delegated the authority to select and appoint the members to the committee, and the remuneration for the members be set at a rate of $135 per meeting, consistent with the remuneration paid to the last committee members.
Council's wishes? Question by the Deputy Mayor?
Just a question. It has the same terms of reference as in the past, or did we change anything?
The terms of reference were amended slightly because there's new responsibilities to this committee, and there's also third parties being required to register and having to file financial forms as well.
Moved by Councillor Jacobs, support by Councillor Dunn. Discussion on the motion. All in favor? Motion carries. A lot of this is going to have to be moved to our next council meeting, but I know we have to do a report on closed session and the consideration of bylaws.
We can move the closed session report to the next agenda.
Okay.
But the bylaws do need to be heard. Bylaw 42-18, a bylaw to provide for the relocation of the culvert over the Hooker Drain, Lot 6, Concession 7, Municipality of Leamington. This is a third reading. Bylaw 43-18, a bylaw to provide for access culverts and a berm over the Lebo Creek Drain, Northwest Branch, Lot 6, Concession 7, in the Municipality of Leamington. This is a third reading. And then bylaw 53-18 being a bylaw to confirm the proceedings of council at its meeting held August 27th, 2018. You'll note that I did not read 14.3 and 14.4, as those reports will be heard at the next meeting.
Okay. Moved by Councillor Verbicki, support by Councillor Dunn. Discussion on the motion. All in favor? Carried. And we are out of time. So it'll have to be moved to the next council meeting. So there's just not enough time to get into anything right now. Anyway, I guess we'll skip everything else. Open session, statement members not to be able. Well, because you want to have a discussion on it, right? Oh, okay. All right, sorry. Then the notice of motion. And what?
So Deputy Mayor McDonald put the motion as included in the council agenda on the floor last meeting, provided the notice, seconded by Councillor Wilkinson. So the mayor would seek a vote on the notice or the motion to reconsider. If that passes, then the matter's on the floor again, and Deputy Mayor McDonald may put another motion on the floor with respect to that.
Okay. Pardon? Okay, so we just need a vote for reconsideration. All those in favor? Opposed? Carried.
So then I will just say that I would direct that the matter be listed on the next closed session council meeting for discussion pursuant to Section 239 2C of the Municipal Act, a proposed or pending acquisition or disposition of land by the municipality or local board.
And seconded by Councillor Wilkinson. Discussion on the motion. All in favor? Opposed? Carried. And motion to adjourn. Councillor Verbicki, Councillor Jacobs, all in favor? Carried.